So the number was 161.
161 stations.
This is separate from phase 1.
Separate from phase 1.
And it's also for Siangena.
That's correct.
Okay.
So you remember we said that the earlier phases, including phase 1 and all the extensions, brought it to 81. This 161 you were talking about is another 80 or another 161?
It's 161, separate from what Siangena had.
Yes.
Yeah.
So phase 1 has got its own train
Number.
stations. And phase 2 has got its own train stations.
That's correct, Chair.
Okay.
Now, was it a smooth process, the award in respect of phase 2?
It was also not a smooth process, Chair. However, in respect of phase 2, at least this time we had an RFP that was issued as part of the tender process. So the starting point, I suppose, was kosher in terms of how things are supposed to be done.
And was it a fair process?
No, once again, it was not a fair process, Chairperson, because instead of PRASA in its request for suppliers to tender asking for functionality, it specified a particular brand that the suppliers or the bidders would have had to comply with or be able to support. And that particular brand was a brand only associated with Siangena.
Before you proceed, let me just ask this question in relation to phase 1. Such non-compliances as we may find in phase 1 with procurement processes, would there be any basis for any official within PRASA who was involved in making any decision to say it was just negligence, I didn't pay attention, but it was not deliberate?
I'd find it difficult, Chairperson, for anybody to say that. The processes are clear. We had a supply chain management, a policy that required us to do things in a particular way. And anybody, especially in that area, because it was a procurement area, we then would want to come and say we're negligent, would not be truthful.
And so are you in a position to say any non-compliances with procurement processes requirements under phase 1 could only have been intentional and deliberate?
That's correct, Chair.
Thank you.
May I just follow up on that? Your answer is an emphatic, no, it couldn't have been non-deliberate. You are emphatic it was deliberate.
Yes, Chair.
Now, do you say that on account of the various irregularities together with the nature of the irregularities, or is there some other basis on which you make that assertion?
It's all the irregularities that really were present, Chairperson. A simple issue of saying put something out to tender and let it be competed upon properly. We all understand, as a state-owned entity and our governance in relation to what we should do in relation to tenders. Section 217, no one can say who works for a state-owned enterprise they don't understand the provisions of Section 217. Fair process is equitable and so on. You can't say that, so if you decide to then have a process that does not even comply with that, which is rigged, in my opinion, then clearly you know exactly what you're doing.
And if you look at all the contracts and the extensions, starting with the first, after the first two to Enzo and Rainbow, Was there any open process that was followed throughout the phase 1 aspect?
No, Chair, there wasn't. There was no RFP issued. There was no open tender issued. Even when, those 8 suppliers were called into that meeting, when they themselves asked for an RFP, we couldn't produce one. We then said to them, develop something that would work for PRASA. I mean, how does one explain that any further?
I've had evidence in regard to other parastatals where it would appear that somebody would say, well, I didn't follow this procedure because the procurement provisions and the supply chain management policy permits that we don't follow these procedures under certain circumstances, and those circumstances are A, B, C, D, E, and in my view, this was an A or B or C situation. But those who look at the whole thing and say, no, it was like self-created agency, or they say, well, there is just no way anybody could have said this fits into this situation. But nevertheless, they are able to put up something. Whether you believe it or not is another thing. Are you aware of anything that those who may not have complied with certain procedures in relation to phase 1, that they are putting up or have put up in the past to try and justify why they didn't comply?
No, Chair. There's just no justification. And there was not even urgency. At least in the case of urgency, you would say, look, we had to deal with things, very quickly, and therefore we had to, the procurement policy would have provided for that. But when you look at, the work that was done, you can't attribute urgency to that. You can't even attribute the fact that this particular company was a sole supplier or was a single source, where in terms of the policy you would be able to do certain things and justify it. In this respect, the fact that in the phase 1 process, you invited 8 suppliers to come in, there was a clear indication that you appreciate that there would be competitors out there who would want to participate in an open tender process. So I can't see any justification from anyone within PRASA who would be able to then say, yes, we had to do this because of urgency, because Siangena, for instance, was a sole supplier, sole source. There was just no justification for that.
In regard to phase 1, and with special reference to the various extensions, would the main people be Mr. Montana and Mr. Mbata?
Yes, Chair.
Who should have made sure there was compliance?
That's correct.
Yes. And in regard to Mr. Mbata, are you aware of any opportunity where he has, any occasion where he has had an opportunity to put up a justification if he has one?
No, I'm not aware, Chair.
You're not aware.
Mr. Mbata.
Nobody confronted him? Or
well, we did, Chair. The organization did, as part of the process of dealing with consequence management and subjecting Mr. Mbata to a disciplinary process. That process was not completed to have allowed him to put that justification forward. In fact, I guess because of other issues and the reasons he gave for not being able to attend the disciplinary process, an unfavorable judgment was then taken against him because he didn't present himself to the hearings.
Yes.
So one would not then understand what Mr. Mbata's...
But if he wanted to put up his justification, that was an opportunity.
Correct, Chair.
He might have elected not to use it.
Yes, Chair.
Yes. What about Mr. Montana?
Well, Mr. Montana was out of the
he was
picture at the
out,
time.
Yeah. Okay, all right. But the one thing you are sure of is the non-compliances that you have pointed out in relation to phase 1 could never have been based on negligence or ignorance of the requirements. They were deliberate.
That's correct, Chair.
Okay.
And just finally, if I could follow up on what the chairperson has pointed out. The phase 1, including the pilot phase, involved amounts exceeding 2 billion rand.
That's correct, Chair.
As I understood your evidence, the only process that was followed, not talking about decision-making process, but process that was followed, is those 8 people being invited.
That's correct, Chair.
Sorry, can you answer?
Yes, the 8 people that have been invited, but once again, I still contend that, it was just selecting 8
Yes,
people and not necessarily putting it out,
Yeah.
as a tender process.
So, actually, what was required was to put the whole thing out to tender.
That's
open
correct, Chair.
tender.
An open
That was
tender.
not done.
No, it was not done, Chair.
The situation, the procurement policy, the procurement provisions did not require that you just pick and choose whoever you want to invite.
No, Chair, not in the
Yes.
circumstances.
Yes.
There
may be
other circumstances,
but this is not one
but
of
this,
them.
not this one, Chair.
Yes. Okay.
And just to finalize the point, that was the only decision in which the BEC and the BAC played a role,
That's correct, Chair.
and the FCIP.
And the FCIP, yes.
So all the other decisions and all the other the contracts that we concluded were done by PRASA officials without any of this being subject to some scrutiny.
That's correct, Chair.
Now, you referred to the amounts having been above Mr. Montana's delegated authority, is that correct?
That's correct, Chair.
In regard to the extensions.
That's correct, Chair.
And is that the position in regard to all the extensions that are involved in phase 1? That he was involved in?
All the amounts were above his delegations, Chair. All the amounts in relation to phase 1 and the extension thereof were above his delegation.
All the amounts?
All the amounts.
Yes.
Yes.
And you said his limit was 100 million.
100 million, Chair.
So obviously, they were far above that.
That's correct, Chair.
And once again, that could not have been out of oversight.
Yes,
He would have known his limit.
that's correct, Chair.
And if he approved these extensions, he did so knowing that he was acting outside of his delegated authority.
That's correct, Chair.
Okay.
Now, in relation to phase 2 now, you say that there was an RFP, but the complaint made was that they had asked for certain brands of equipment to be used.
That's correct, Chair.
And
I'm sorry, Mr. Soni, please don't forget your next question.
no.
In terms of the supply chain management policy and in terms of other instruments and prescripts applicable as you know them at PRASA, are there circumstances under which the group chief executive officer would be or was authorized to exceed his delegated authority on certain conditions?
No, Chair. There was
No,
none.
not at all.
Not at all.
Yes.
If there was anything above his delegation of authority, even in terms of signing of contracts that are
Yes.
above his delegation of authority, he
Yeah.
would have been given that permission by the board to say, we
Yes.
then authorize you,
Yes.
Group CEO, to then enter into this contract.
Yes.
After the board would have obviously considered the issues and
Yes.
have supported the submissions that were made to it.
Yes.
But otherwise, he just wasn't.
Yeah, it wouldn't happen.
No,
He would have to refer that to the board.
that's correct, Chair.
Yeah. Okay.
Now, In respect of the fact that certain brands had been identified to be used to comply with the tender requirements, what is process policy?
Chair, I mean, our policy, does not support the mentioning of brands when we go out into the public requesting for tenders to be for people to participate in our tenders. So that issue is just not there. You can't mention a brand in a tender process because then it makes it uncompetitive.
When you talk about mentioning, you mean in
the tender
documents that you issue to the public?
That's correct, Chair.
Yeah.
You can't specify a brand.
Yes,
Yeah.
yes. You can just specify what you need.
That's correct, Chair.
Yeah.
But not a brand.
Yeah.
And was this a complaint that was made by any of the tenderers?
Yes, it was, Chair. In fact, two of the bidders, had a problem with it because the brands that were specified favored Siangena to the detriment of the other bidders.
Now, when you say the brands that we those brands we identified in the RFP,
That's correct, Chair.
and in respect of favoring Siangena, why do you say that the use of that brand would favor Siangena?
Chair, the way this process started, in fact, was that there was an unsolicited proposal, effectively, that was made by Siangena in relation to phase 2. So in there, it was very clear that, their brands are the brands that support the Babylon and Dalmea system. And that was then what was used, effectively, to take the matter out to tender, reflecting those two brands. And it followed from the unsolicited proposal that was made by Siangena in relation to phase 2.
And who would have been responsible for the inclusion of the brands?
Well, the supply chain management area, and in this regard, the CPO, the Chief Procurement Officer at the time, was a gentleman by the name of Mr. Josephat Pungula. So he ran with this process, from a procurement perspective.
Had he replaced Mr. Mbata? Or?
Yes,
Oh,
Chair.
okay. Thank you.
And in relation to the issue of this RFP, how long before the issue of this RFP had Mr. Pungula replaced Mr. Mbata?
I can't remember the times, Chair, but what I know is that at the time that this particular process was involved, Mr. Mbata had no longer been the CPO. Mr. Pungula had come into the fray. I can't confirm the times.
Did Mr. Mbata resign when there was a trial hearing, or what had happened to him?
No, Chair. He got moved to another area within the
Yes.
within the organization.
He's still there?
Well, he left now because the disciplinary process
Continued.
that continued in his absence found him guilty.
Yeah.
And therefore he was dismissed.
Yes,
Yes.
okay. Was that disciplinary process chaired by an outsider by any chance?
Yes, Chair.
A lawyer?
Yes.
And would there be a recent decision that he or she made?
Yes, Chair.
Okay. Do we have that?
We will get it.
Okay, yeah. So it's important to
Yes.
to have that. And he didn't take the issue any further, Mr. Mbata?
Well, he went to the CCMA, Chair.
Yeah.
Yes, to challenge the dismissal. So that process has still not been completed.
It's still going
Yes.
on? Okay.
So just so that the chairperson has an idea of timelines, Mr. Pungula replaces Mr. Mbata.
That's correct, Chair.
At the time, at that
Can
time,
you have the time frame, maybe, to say Mr. Mbata was moved from procurement more or less at a particular time, that particular year, and then Pungula came in? You remember when that was?
If anything, I think Mr. Mbata, if I recall, Chair, Mr. Mbata was removed as the CPO perhaps end of 2011, 2012.
Oh, okay.
Yes.
Okay.
Because this process is a 2013 process. That's the second phase.
But the disciplinary hearing would have taken place when?
It's not long ago, Chair. Remember, this was subject of a investigation.
Yes.
So what had happened is that because also the public protector had picked this up, now as part of the remedial actions, PRASA obviously had to follow consequence management processes to make sure that those people that had been identified in these irregularities.
So the disciplinary process is a recent...
It's not, yes.
A year or two or so?
It's last year, actually, Chair.
Okay.
But in between, after Mr. Mbata had been removed, you say he was removed, he moved to another section of PRASA.
That's correct, Chair.
And he remained at PRASA until the disciplinary inquiry.
That's correct, Chair.
So from about 2012 to about 2018-19, he remained at PRASA.
That's correct. He was the Chief Information Officer.
Was he removed by Mr. Montana?
No, Chair.
Uh-huh.
It was the last board that had the board,
Ms.
Kweyama's board,
Yes.
that initiated the disciplinary proceedings.
Yes.
And appointed a law firm
Yeah.
to run with those processes. So it was last year.
Oh, his removal as CPO was also a recent thing.
Yes, Chair.
Yeah, okay.
So I thought he'd been moved from CPO.
No, sorry, Chair. CIO, Chief Information Officer. So CPO is the Chief Procurement Officer.
Yeah, no, I understand. But initially I was under the impression that he was removed as CPO around 2011, maybe 12, maybe 13. But then I thought you were saying it only happened recently.
No, Chair. CPO as the Chief Procurement Officer was around 2011-12.
When he was removed
That's
from
it.
there.
So from that
would have
position.
been during Mr. Montana's
That's
time.
correct, Chair.
But you say he was not removed by him.
No, he was not removed. He was removed by him as a CPO, but he was not dismissed by Mr.
No,
Montana.
I mean removed from the position of CPO.
That's correct. He was removed by Mr.
Mr.
Montana. That's
Yes,
correct,
okay.
Chair.
No,
Yes, sorry. We are at cross purposes.
Yeah, no, that's fine.
Was there any reason given for Mr. Mbata to be moved from the position of CPO to CIO?
I wouldn't know the reasons, Chair. I mean, I think the practice at PRASA was that you found ourselves being moved ever so often. So one never understood the rationale of, moving people. It happened to a lot of us that we were moved. I mean, at one point, I think as employees, we would make fun of the slogan of PRASA to say, be moved, referring really to the employees within the organization.
Within PRASA, what would be a more prestigious position, being the Chief Procurement Officer or the Chief Information Officer?
Sure, I wouldn't say.
Or was it a parallel?
That was a parallel move.
Same, more or less same status?
Yeah, it's got no salary increase. It was a parallel move. So because,
okay.
Yeah. Because at one point, Chairperson, the CPO was an executive position, right? And that's what Mr. Mbata was. He's always been an executive in the organization. When Mr. Pongola came on board, it was then a GM position, a general manager position. So he did not have the same status as that of Mr. Mbata. So there were changes to the operational structure that did not place Mr. Pongola at an executive level. However, Mr. Mbata, from being moved from the CPO at executive level, went to the CIO, which was still an executive appointment.
Now, one of the things you say in the if you could read the last sentence of paragraph 34, Ms. Ngui.
Yes, I'm saying it's not surprisingly, given that the specs were tailor-made for Siangena, it was awarded the contract
Now, you've read the... Oh, sorry. Yes.
Well, I don't know who drafted the affidavit that specs, I guess, should have been specifications.
Specification.
Given the specs, oh, sure, Chair, sorry. It was an urgent process, Chair.
Okay.
Sorry.
All right.
But in the Swifambo matter, relating to the purchase of the locomotives, that's one of the reasons that the SCA expressly said the tender was invalid, because the specifications for the locomotives had been tailor-made for Swifambo. You recall the judgment?
Yes, Chair.
When you used the word tailor-made in your affidavit, did you have that in mind?
Yes, Chair. I mentioned earlier that it was an unsolicited proposal that was made by Siangena to PRASA for the rest of the stations. So effectively, tailor-making it was making it to suit the proposal that Siangena had made.
So the specifications that were put out in the RFP, how were they related to this, what was offered in the unsolicited proposal from Siangena?
Well, the mention of the brands, Chair, is a giveaway, in the circumstances, because, only Siangena could support Dalmea and Babylon, and therefore the other bidders were excluded from participating.
What brand was this that was mentioned?
It's a brand, it's called Dalmea, and the one was Babylon. That's it.
Why would Siangena be the only one who could access it?
I guess because they were they were regarded like the OEM, the original,
manufacturer.
That's it.
Yes.
Yeah. So they're the ones that supported. They were the only ones that could support that brand.
Okay. Thank you.
So, can you recall what the amount of phase 2 was, more or less?
It was over 2 billion rands, Chairperson.
Over 2 billion rand.
Yeah.
Phase 1 was initially 1.1, then 1.9, but ultimately 2.2 or thereabouts.
Yes, with the inclusion of the
billion.
250.
Yeah.
Yeah.
And then phase 2 was
Over 2 billion rand.
over 2 billion
Yes,
rand.
it was 161 stations, Chair.
Yes.
Yeah.
Okay. But just to, we were talking about the brand now, and you were making the point that only Siangena could come up with the brand that was required. So the position that in regard to phase 1, only Siangena was told that they needed to include a funding model
Yes.
in their bid
Yes,
or
Chair.
in their proposal,
Yes, Chair, because they're the only ones.
and the others were not told.
Yes, Chair.
In regard to phase 2,
Babylon.
then the brand was put in that ensured
It's
that
Siangena.
only Siangena could win.
That's correct, Chair.
So phase 1, because the others didn't know about the funding model, they stood no chance of winning.
That's correct, Chair.
And under phase 2,
It's the
because
brand.
the brand was, there is a requirement of a particular brand, they also stood no chance of
That's
winning.
correct, Chair.
Yes. Okay.
If I could just go back to phase 1. When you say Siangena was told, is that something you know or something you assume because they had included a funding model?
Well, what I understand, Chair, is that as part of the discussions that happened, when there was I started by saying it was a subcontractor. And from a subcontractor, they got to be given the 7 other stations. So they were already in the system, and they were communicating with people within PRASA, and discussing how best it is to assist PRASA in doing this project. And therefore, with those discussions came the issue of the funding model to say, no, we'll help you out. If you can't afford it, we'll help you out. And therefore, they are the ones that knew that, that would be received very well by PRASA, because they had been interacting with the people at PRASA to the exclusion of obviously all those other 8.
Otherwise, how would they have known that PRASA wouldn't have the budget to fund this? Right?
That's correct.
Yeah.
The discussions were happening internally.
Yeah. Okay.
And you say that on the basis of the investigation that you did in preparing for the founding affidavit in the review matter.
That's correct, Chair.
All right. Then, as seems to be the practice, there is the phase 2, and then there's something added to it. Would you tell the chairperson about that addendum to that phase 2 contract?
Chair, the addendum was a mystery to PRASA.
I'm sorry, Ms. Ngoy. It's just so difficult for me to understand how anybody could think that a job for 2 billion, over 2 billion, could really not go out to an open tender in circumstances where there is no justification relied upon that's provided for in procurement provisions and supply chain management to say we are justified in not following this procedure. It's just so...
It's bizarre, Chair.
It's you're talking big amounts. And obviously, there will be questions about that. If you're talking small amount, maybe people might not notice. If you're talking big amounts, you have to know that people will want to find out.
Yes, Chair.
And people will ask questions. So I just don't understand. What are the answers that you think you will give when you're asked questions? You understand?
I get you, Chair. I do. And I think, that's why the investigations revealed, the amount of corruption and that maladministration and all sorts and fraud that were happening in these processes and non-compliance with legislation. And that's why at the time, PRASA, the board of Dr. Popo Molefe decided we need to have these contracts set aside. Because the investigations revealed these issues that could not be explained, Chair.
Well, I don't want us to forget, Mr. Soni, before we finish on phase 2, we need to go back to the question of deliberate, intentional flouting of processes and procedures as opposed to oversight, ignorance, or anything like that, to make sure she covers all of those as she sees things and as she saw the facts that emerged from various investigations. It's important that those be dealt with head on, to say if somebody is going to come and defend non-compliances, they must know that the suggestion is that it was intentional, it was deliberate.
Yes.
There was no oversight here.
Absolutely.
Yeah.
And we must have all the documents available.
All the documents available, yes. Yeah.
Now, sorry, we were talking about the addendum, and you say there was a strange aspect to this. Please tell the chairperson what it is.
Chairperson, when the board of PRASA, at the time of Dr. Molefe, was looking at these contracts, we were given an instruction by the board to say, tell Siangena to stop working because we are not going to pay them because of these irregularities. And Siangena brought an interdict against PRASA, the High Court in Pretoria. And as part of their papers, they produced this addendum. Now, nobody at PRASA knew about the addendum. We searched, and the business unit that was managing the contract of Siangena was not even aware that there was an addendum. We searched, the documentations within PRASA looking for this addendum. It was not found. So this addendum was produced by Siangena for the first time at that meeting, at court, in fact. And we were all alarmed because we didn't know what the document was for. And we searched, vigorously, effectively, to try and find this document. And we just couldn't find it in the records of PRASA. But this document was signed by Mr. Montana.
Have we got it here?
We don't have the document here, Mr. Chairman, but we will obviously
It's
get it.
critical.
Yes.
It's part of the bundle, Chair, for court. But
Yeah.
we'll have to bring it also here.
Yeah, I know, I think, Mr. Son, you were trying to avoid bringing
A lot of things.
too many documents into the commission, but some of them are critical.
Absolutely.
Yeah. So it's going to be important to go through again and maybe revise your selection. Okay. Now, what do you remember? What kind of date that addendum would have been signed?
I think it was, if I'm not mistaken, if I recall, Chair, it was April 2014.
Yes.
Yes.
Yes. Okay. I guess Mr. Son is still going to ask you about what about its contents.
Yes. Well, can I start off by making this point that around the 31st of March 2014, Mr. Montana had formally said he was going to leave PRASA.
That's correct, Chair.
And so this document is signed after that time.
That's correct, Chair.
And Mr. Montana signs on behalf of PRASA.
That's correct, Chair.
Now, what was what services were Siangena to provide in respect of that addendum?
Chair, it was effectively a type of a maintenance contract, where Siangena, in relation to phase 1, would replace, certain equipment with others, because from a phase 1, I think at the time had run for a period of 3 years, and so if there needed to be a change to the equipment, then Siangena would again come in and be able to provide that maintenance. But what we found interesting also about this addendum was that you would expect that there would be service level agreement to say this is how you're going to do things, and this is the process that you would follow. We could not find that service level agreement that related to that addendum. But what we understood was the requirement at the time was that PRASA would then have to pay Siangena an amount of, I think it's 10 million.
A month.
A month, 10 million a month for those services. So when Siangena was suing PRASA through the arbitration process for monies owed, it would include this 10 million.
Now, we are dealing with phase 2. Phase 2 related to an additional
161 checks.
61
Yes.
train stations.
Yes.
And then there is an addendum.
An addendum.
Yeah.
For
And
maintenance.
the addendum is for maintenance. Maintenance of what? Of the Train stations.
Of the equipment that Siangena would have
Used.
Yes, so
Yeah.
if it needed to be
be
changed,
maintained,
that's
yeah.
right.
Yes.
So that addendum related to them having to do that work.
And do you remember how long, what the duration was intended to be for that, for those services to be provided by Siangena?
I can't
terms of the
remember, Chair.
addendum.
I can't remember.
Oh, a few years?
Yes, it would have been. Remember
Yeah,
that,
a few years.
yes. So they,
Yes.
the phase one project
Yeah,
was actually near completion
yes.
at the time.
Yes.
And then this addendum came
The
up.
addendum related to phase one and phase two?
Phase one
or
and,
just phase one?
I think it was phase one and two, Chair, but I stand to be corrected. I'll
Yes.
have to check
But
that.
phase one definitely.
But phase one, definitely.
Yes.
Yes, Chair.
And you say they were to be paid 10 million rand a month,
That's correct, Chair.
which means in 12 months, that would be 120 million, huh?
That's correct, Chair.
Yes. And nobody knew about this addendum, that's why you had to look for it.
That's correct, Chair. We saw it for the first time when
Yes.
Siangena's attorneys produced it. We didn't know
Yes.
about it.
Yes.
When you say they produced it, that surely would have been part of the papers they presented to court.
That's correct, Chair. That when they served us
It was
with the papers,
attached to
yes,
the papers.
that their papers in support of the interdict. That's correct.
But can I just raise this? That maintenance agreement was in relation to equipment that had been supplied in phase one.
That's correct, Chair. Definitely phase one. As I say, I can't remember if it extended to phase two.
That equipment, just given the times, because this is 2014, that equipment would be at least 2 or 3 years old.
That's correct, Chair.
Let me ask you this, and I'll just ask as a general proposition. This was electronic equipment, would I be correct?
That's correct, Chair.
But surely in those 2 years, equipment would have evolved so much that that equipment would effectively have been almost ancient when one looks at technological development.
Yes, Chair, it's possible.
Has anybody examined whether such a contract was worth entering into? In other words, paying 10 million rand to maintain equipment that might now be outdated technologically speaking.
Chair, that's why, one is saying it was just a bizarre situation that we were faced with, especially when the business that was managing that particular contract was not even aware that there was this addendum that related to maintenance of the equipment. So, we were all surprised to see this document, and we just didn't know how it came about. So for us, it was just, in fact, we thought that this document was created outside.
Do you remember whether somebody within PRASA had witnessed Mr. Montana's signature on the addendum?
No, Chair.
There was no witness.
No, I
Or
can't
you
remember
can't
if there was.
remember?
Yeah, I can't remember if there was witness, but
But in all
definitely
probability, you would
it
have
was.
remembered if it was somebody you knew that witnessed.
That's it. Yeah.
Yeah. But you can't remember whether there
No,
was.
I can't recall.
yeah.
All I know that the document was. All I remember, Chair, is that the document was signed by Mr. Montana.
Yes.
Yes.
And some of us are not so good with technology, Ms. Ngoy. But in terms of the old language, I want to say, when you went through the file,
Yes.
to PRASA's file, where all documents, agreements, and correspondence relating to that project were supposed to be, there was no, that memorandum was not there.
No, Chair.
You probably didn't go to a physical file.
We looked, one of the companies that we had employed during the investigation, Fax Consulting, could basically, remember I spoke about our computers being imaged, so could basically go into the information of PRASA and pull out,
Yes.
anything that we requested.
So it definitely was not there.
It was just not there, Chair.
Yes. Okay.
Now, The interesting thing about...
I'm sorry, Mr.
sorry, go
Sonny.
ahead.
I'm terribly sorry. Please don't forget the point you wanted. Now, you say that the investigators had imaged your computers, Prasa's computers, and they didn't find this addendum, is that right?
That's correct, Chair.
So, in other words, as far as you understand the position, that addendum was never entered into any Prasa computer,
No, Chair.
and therefore it could not have been created from a Prasa computer.
That's correct, Chair.
It could only have been created from outside
Elsewhere.
of Prasa.
Yeah. That's the conclusion we came to, Chair.
Yes, because
yeah.
otherwise all documents that are created within Prasa
Would have been found.
would be found
Yes.
within Prasa computers.
That's correct, Chair.
Okay.
Now, the interesting thing about, and I know you've mentioned other interesting things, but the interesting thing about this addendum is it's called an addendum to phase 2. Am I right?
That's correct, Chair.
But it actually related to phase 1.
To phase 1. Because you couldn't have had, phase 2 was just beginning. You know, phase 1 would have been the one that would require changes to the equipment. But yeah, I mean, that's why a lot of things didn't make sense, Chair, when you looked at it. Our conclusion with the investigating team and our attorneys was that there's clearly something amiss here. It didn't make sense.
Well, in any case, phase 1 had phase 1, then it had an extension, then it had an addendum, all in the space of about 6 months.
Effectively, Chair. That's correct.
And then 3 years later, it would indeed be odd to say that this is a further addendum to phase 1.
That's correct, Chair.
Now, sorry.
Are you suggesting in any way that the reference to in the addendum to phase 2, which was wrong from what you have said, was deliberate?
It was premature, Chair. You couldn't have made reference to phase 2 because in terms of, remember, also one understands that there's warranty periods, you know, in relation to the equipment that would have been provided to PRASA. So phase 2, they were still in the process. I mean, phase 2 was only completed, in fact, last year.
Yes, no, what I'm asking is, it's strange you have said that the addendum is written phase 2 because phase 2 is just starting at that time.
That's correct, Chair.
Phase 1 got completed 3 years before.
Yes, Chair.
Is that right?
Yes, Chair.
So I'm asking the question whether you think the person who wrote phase 2 on the addendum did so intentionally, or it might have been oversight.
I think it was an oversight, Chairperson. I think it was an oversight.
You think it was an oversight?
Yes.
Okay.
Yeah, I think it was an
All right.
oversight.
Okay, no, that's fine. You don't think somebody may have thought it's going to be strange for a document that comes up 3 years after the completion of phase 1 to be written phase 1 in terms of maintenance, and then wrote phase 2 because phase 2 is just starting, so it would be current. You think that's unlikely. You think because phase 2 had just started, what was being talked about was phase 2, and then in the process somebody wrote phase 2.
Well, Chair, the whole thing just didn't make sense to us. You know, here we are in the midst of the phase 2 work still being done. You know, it hasn't been completed. And you then, you know, create this addendum for purposes of phase 2. instead of, you call it phase 2.
Yeah.
But you refer to phase 1, which was supposed to have been completed at the time. It just didn't make sense. I mean, my
So
view,
it may be oversight, you say.
my view is that, you know, in a haste,
Yes.
you know, you then don't check what it is that you've put in the document.
Yes.
Yeah.
Okay.
Well, can that be correct? And I'm saying this in this, the document is headed addendum to phase 2, but the substance, the work to be done is in relation to phase 1.
Yes, Chair. And that's why I'm saying, you know, because we could not make sense, we couldn't find this document, the only thing that we could deduce was that, you know, things were done in a rush, and therefore people didn't apply their minds when they were putting the document together.
Well, what council is saying, in effect, it would look strange that somebody who knows that this document relates to work that belongs to phase 1 would write at the top phase 2 because of oversight,
Yes, Chair.
when he knows that the whole document is about phase 1.
Phase 1, yeah. Yes, Chair. Yeah.
There must be so much to remind him that this is about phase 1,
Yes,
and therefore for him to change this if it was oversight.
yes, Chair. Look, I don't understand
Yes,
really what
yes,
happened. I
yes.
mean, one can explain it, as I say,
Yes,
you know.
no, that's fine,
This
yes.
was just pounced on us.
Yes, no, that's right.
And I suppose all one can do is draw inferences from all the facts put together,
That's correct, Chair.
including the fact that this is about the time Mr. Montana is leaving.
That's correct, Chair.
Now, just finally on that, in respect of that addendum, whether it's correctly called addendum to phase 1 or phase 2, had any payments been made by PRASA between April 2014 to the time that Siangena sued for the money owing in terms of that contract?
Are we talking to phase 1?
No, this addendum here, that's,
No, there was no payments in relation to the maintenance. Remember, this was maintenance. So we didn't, because we didn't know about this, so nothing could have been attributed to the payment in relation to maintenance. So the payment that was done in relation to the work that Siangena had performed for PRASA was in relation to the contracts themselves and not the maintenance portion.
okay. But listen, we're making a slightly different point. This agreement is concluded in April 2014.
That's correct, Chair. Well, it's purportedly. I don't want to say it's concluded because I don't know.
No, but that's what we have before.
That's correct, Chair.
Now, that agreement says PRASA must pay Siangena 10 million rand a month for maintenance of phase 1 equipment.
Yes, Chair.
Now, that 10 million rand a month becomes due at the time the agreement kicks in.
It should.
Well, I mean,
At the time of signature or soon thereafter,
indeed, Chair.
is that so?
Yes. So,
Okay, so it was signed in April 2014.
14.
The actual performance of the maintenance work by Siangena was supposed to start immediately
Well, it couldn't have started immediately, Chair. It couldn't have started immediately.
because they were busy with phase 2.
Well, you've got warranties,
Yes.
you know, that would help you at
Yes,
least with,
Maintenance.
changing, maintenance issues in
Yeah.
relation to the phase 1.
Yeah.
So it would then have to kick in after the warranty period lapses. Yes.
But do you remember up to when the warranties would have been valid?
I don't recall, Chair. I don't remember.
Is the position that you don't know whether at the time of the signing of the addendum,
The warranties had
were no longer operational?
I can't recall, Chair.
You can't recall.
I don't want to make submissions to that.
see, because that too creates a problem about the propriety of entering into that contract. Mr. Montana is about to leave. If the warranty is only going to expire 6 months from then, what is the need to enter into the contract before he leaves?
That's correct, Chair. I mean, I will say again, you know, we found it interesting that this document was just produced at the time that it was produced. And the fact that we couldn't find it, and that's why I'm saying, Chair, internally, in relation to the payments for maintenance, we couldn't find, you know, the fact that PRASA had paid for maintenance anyway in relation to the phase 1 contract. The business unit that was responsible for this contract, if they knew about it, would have known that they would have had to pay this maintenance as well. But because they didn't know, you know, there wouldn't have been any justification from them to pay.
What's the unit at PRASA that...
It was PRASA Chris. PRASA Chris. It was the corporate real estate.
Yes, yes. They didn't know
division.
anything about it.
No. We asked, the CEO at the time was Ms. Tarangubani.
Yes.
And she looked
She didn't
with her
know about
team and they didn't know about it. We
They
asked
never
procurement.
asked for anything like that,
Well,
as far as you know.
No, when we asked as we had received the document. So we went back and said, we need to check ourselves whether this document exists. We went to procurement to ask. Procurement didn't have a record of the document. We went to the business unit that was managing the project to ask if they knew about this document. And they didn't know as well.
But it raises, sorry, Chair.
Maybe do ask and then I'll come back.
I don't mind, I know my question.
Just to complete the picture now, I'm taking you to something else. Payment by PRASA to Siangena of the work done in regard to phase 1 over the 3 years before this addendum was signed, did PRASA pay anything?
Yes, we did, Chair. I think we paid over 1 billion.
Or had you in the meantime found money?
Yes, we had money, we paid over 1 billion.
Okay.
I think in respect of phase 1,
Yeah.
at the time that the board requested us to stop really paying Siangena,
Yeah.
we were owing Siangena about 600 million.
So you would have paid about
1.2.
1.6 billion.
Yeah.
For
effectively,
phase 1.
For phase 1,
Okay.
yeah.
Okay.
Now, what is also intriguing is, the first time you get to know about this document is when PRASA tells Siangena to stop working.
That's correct, Chair.
Now, if Siangena, if there was such an agreement, and coming back to the point you made, we must accept, we don't know if there was an agreement, but if there was such an agreement, then one would expect that if money is due in terms of the agreement, Siangena would have asked for payment in terms of that.
They would have invoiced, definitely, Chair.
And had there been any...
I'm sorry. Just want to please just repeat that question.
Yes.
I didn't follow.
So, if there was such a contract, then one must assume that at the time you tell them to stop, money is owing to Siangena, because that's why they don't want to stop.
That's correct, Chair.
Now, based on the investigations you had done and the team, had it been found out whether Siangena had sent any invoices in regard to that 10 million rand a month?
Chairperson, what happened is that in relation to phase 1, this maintenance contract was obviously not known. So there was no submission of an invoice in relation to the maintenance of it. What we then found out was in relation to the matters pertaining to phase 2, that in Siangena's invoices, there would be reference to this maintenance agreement. But obviously at the time, we had put a hold, the board had put a hold on payment of these amounts to Siangena, so no monies would have been paid in relation to this addendum for Siangena, but they included it in the amount that PRASA owes them.
I'm sorry. Just, so I need to get my time frames right. Round about when, in terms of month and year, was PRASA discovering, or were you discovering, did you discover that there was this addendum? It was signed in April 2014, but when did you discover? When was it that Siangena took you to court?
We asked Siangena to stop. I think it was in 2016. Late 2016, yes.
Yes.
It could be 2016, 2017, when the board said, look, based on the investigations that we have, stop paying Siangena.
Yes.
So it was...
So it would have been around, it would have been 2017.
2016, yeah, Che.
Yeah.
The board of Dr. Popo Molefe was still in place.
So that was about 2.5 years or thereabout after the signing.
That's correct.
So during that period, PRASA had not made any payment in regard to this addendum.
No, Chair.
The maintenance work.
Yes, Chair.
It had made payments in regard to phase 1.
Yes.
In terms of the
work that had been done.
The work that had been done.
Because there was a process also, Chair.
But you say that Siangena had included references to this addendum and maintenance work in their invoices.
After we found out.
Oh, after
remember,
they
still
found out.
Yeah, they still bill us, Chair. They continue to bill us.
Yes.
In fact, what happened, Chair, with the interdict, we lost the interdict, and so they were allowed to continue to work.
Yes.
And so
then they started billing you for the first time in regard to this addendum.
Yes.
So they had this addendum, which was signed in April 2014, but didn't say anything about payment. Did you get to know at any stage whether from after the signature, the signing of the addendum, whether they actually did the work in terms of the addendum?
No, Chair, there wasn't any evidence that showed that,
But they did the work.
Yeah, there wasn't. What I know, Chair, is that the CEO, Mr. Ms. Tarangubani, when we interviewed her in relation to wanting to understand what actually transpired, she indicated, the thoroughness of looking at the work that Siangena would have done before payment. And they would question, obviously, things that they didn't agree with. So, speaking to her, there was no mention of the fact that this contract was in existence. They didn't know about it.
And I guess they wouldn't have performed maintenance work without the client knowing.
Of course.
That they were performing maintenance work.
Yeah. We would not.
Okay.
But one thing, until the interdict application by Siangena, there is no invoice from Siangena relating to this 10 million rand a month.
No, Chair.
Let's repeat that.
Until the interdict application Siangena brought, there is no invoice from Siangena to PRASA.
There's no invoice, Chair.
And what would you then deduce from the fact that there is no invoice? We're now looking at 2017 when this interdict application is brought.
It's suspect, Chair. One wonders what could have happened, and one is thinking about, the issues of, once again, corruption and all sorts.
I would think that even if you are very rich, if you have done work that entitles you to 10 million rand a month, you can't forget to put in an invoice.
No, you can't. You can't. That's why I'm saying, Chair, it was just bizarre for us to say, now there's this other thing.
Yes.
And now there's this other expectation from PRASA in terms of payment requirements, which we didn't seem to see.
Yes. Mr. Sonny, or maybe Ms. Ngoye as well. if this hasn't been done, it is necessary to get somebody in the relevant train stations where the maintenance work would have been done, who would have known if maintenance work was done in the particular train station. That's apart from somebody staying at head office, who it may be important just to, who says, no, I was here during those years. There's no way anybody would have come in here and performed maintenance work without me or my staff knowing, and they had come in my absence, my staff would have told me.
Indeed.
We'll request that, Chair.
Yeah.
And Mr. Chairman, that interdict application now becomes quite important as well, because one would then see what case Siangene is making in relation to.
Yes, yes. So we need to get those papers as well.
Just now, in respect of these different phases, you, in paragraph 39, wish to emphasize certain matters. Will you do so, please, to the chairperson, Ms. Mbui?
Chairperson, in paragraph 9, I say, in respect of all these contracts,
I'm sorry, what paragraph?
paragraph 39,
39,
of the supplementary affidavit.
Yes.
I state that in all these contracts, PRASA was simply not authorized to proceed with the works contemplated in phase 1 and phase 2 and the addendum. These transactions were not budgeted for, and no approvals were even obtained from the Minister of Transport.
I don't know if you deal with this elsewhere. Under what circumstances would the approval of the Minister of Transport be required?
Chairperson, there's a materiality issue that applies within state-owned enterprises. So, you know, but also...
What is the materiality issue?
The materiality in terms of the amount of money that is regarded as material. But what I found at PRASA, Chair, is that I'm not sure that we're doing the materiality process correctly. Take, for example, right now the materiality that has been identified in terms of the amount at PRASA is sitting at 58 million. But then you have the authority of the group CEO at 100 million. How I understand these two work, especially in relation to my experience from Transnet, was that you would agree the materiality with the shareholder. So anything that is above the materiality that you would have agreed with the shareholder would then have to go to the shareholder for approval. So if you look at these amounts, I mean, I think at one point, PRASA was sitting at 48 million as a materiality framework, a number that was included in our framework. But the authority of the group CEO would have been above that. So effectively, you couldn't have, and this is my submission, Chair, you could not have a materiality framework of a particular amount and a delegation of authority above that materiality framework. It shouldn't have worked like that. And in any event, anything above a billion in relation to what PRASA would have indicated as a materiality framework would have required the Minister's approval.
So are you saying the position, as you understand it, is that if a state-owned entity is going to commit itself financially beyond a certain amount, it needs the approval of the relevant minister?
That's correct.
In the case of PRASA, that would be the Minister of Transport.
That's correct, Chair.
And you say the reference to materiality is really refers to that threshold.
That's correct, Chair.
That is specified.
In the materiality framework.
Yes.
Yes.
And I guess the reference to materiality must simply means once it reaches a certain point, the financial commitment reaches a certain point, it matters for the shareholder.
Yes, Chair.
Therefore, you must tell the shareholder and get approval.
And also in terms of the PFMA, Chair. It
Also
would
in
be,
terms of
yes,
PFMA.
it would be a major acquisition
Yes.
for PRASA,
Yeah.
to have entered into these type of transactions. So PRASA was acquiring assets, that were, material.
But the requirement that you must obtain the approval of the minister, materiality issue, is that provided for in the PFMA? Is that provided for in some other legal instrument?
The PFMA talks to that acquisition of a significant asset, right? And what happens is that for you to be able to determine what is material, you agree the figure with the shareholder. So that would be incorporated in the shareholders' compact, which is the agreement that the minister concludes with the board. So that should the board, should an amount be above
Yeah.
that which is agreed
Yeah.
with the minister,
Yeah.
PFMA would kick
Minister's
in.
approval must
Yes.
be obtained.
PFMA would kick in as well to say
So the PFMA talks about a material,
a significant asset,
a
yes.
significant asset.
Asset, yes.
Oh, okay.
Yes, and then materiality would
Yes.
then determine really
Yes.
what would then be regarded as significant in the bigger scheme
Yes.
where the organization is concerned.
Okay. I think, Mr. Soni, if we can get the relevant
Section 54.
provisions,
Yeah.
yeah. and
It's
you can
within
just
Section
put them
54 of the
out, yeah.
PFMA, Chair.
Yeah, okay. Thank you. So you say the materiality threshold, if I can call it that, in regard to, as between the minister and PRASA, was 48 million
At the time, Chair.
at the time.
Yeah, because I think we're sitting at
So
50 odd million
here
right
we're
now.
talking about billions.
Yeah, we're talking about billions. It was
Yeah.
too big an
And-
amount for
and-
PRASA not to engage the minister and get his
Yes.
approval.
Yes. Of course, in regard to, oh, that's in regard to the whole contract. The addendum would, oh, well, for the whole year, the addendum would have been above the threshold.
That's
too.
correct, Chair.
Yes. And these thresholds would have been well known, obviously, to the group CEO.
Yes, Chair.
Yeah, okay.
Then, Ms. Ngui, in your affidavit, you deal with certain financial dealings between PRASA officials and an attorney associated with Siangeni.
That's correct, Chair.
Let's just go back to a point you made earlier as to who was driving the process just prior to phase one starting. Who was the PRASA official at the head of that?
I speak about Mr. Gancho, Chair.
And the decisions that were
I'm
thereafter.
sorry, what was Mr. Gancho's name? Do you know? I haven't seen the name here, just see the surname.
I'm very bad.
Okay, maybe somebody will
Forget
look
it.
for it. In the meantime, you can continue. I think,
I know the name. but I forgot.
Can
We'll
I-
have to look for it, Chair.
I'll make it available.
it can be found
Yeah.
later, okay.
Yes.
Now, and who was making all the decisions
The
in
decision,
relation to these contracts?
the decisions were made by Mr. Montana.
Now, the contracts or the transactions that you talk about, and you say they cast a giant shadow over the propriety of these contracts, whom do they concern?
They concern both Mr. Gancho and Mr. Montana. Chair.
Now, in your founding affidavit, in the review application, you identified those at paragraph 21, am I correct?
That's correct, Chair.
Could you tell the chairperson very briefly Well, let's start off with, in regard to Mr. Montana, how many transactions do you say are matters of concern?
There were 4 property transactions, Chairperson, that were picked up by the investigators.
And in regard to Mr. Ganshaw?
Mr. Ganshaw, there was 1 property that was picked up.
Right. So let's start off with Mr. Montana. There are 4, you say.
That's correct, Chair.
Would you identify those? And you don't have to give too many details, but if you could just tell the chairperson what the essence of those contracts are and why they prompt concerns.
Well, Chairperson, we say they're property transactions because they related to the houses that Mr. Montana had bought at the time. You know, the first transaction.
And you said at the time.
At the time, this Yangena contract was, you know, we were
the
dealing with
original or the addendum.
all of it
During those years.
during those years.
Okay, all right.
So,
And that's like 2011 to
yes,
2015 or thereabouts.
yes.
Yes, okay.
The investigations pick up that there's a number of contracts that property dealings that Mr. Montana was involved in, and 4 of these, you know, were identified. And what was bizarre, Chairperson, about these transactions was, as it's been alluded in the affidavit, was that you had an attorney who at the time was a conveyancer, or was the attorney, one would regard him as the attorney for Siangena, was the person that was, you know, assisting Mr. Montana in the procurement of these contracts, of these properties. And when you look at the amounts involved, Chair, you would recognize that there were substantial amounts. For instance, one of the properties was above 11 million rand. And what the investigations picked up was that these properties were not bonded. So
All 4 of them.
the first one was he bought the property for 1 billion, not 1 billion, it's 1.odd million, and he sold it for 6 million. So that one.
Yeah, that has no issue.
Yes, there was one for about 11 billion. Million, sorry, Chair, not billion. Million.
Sorry.
Okay, let's start
Mr.
afresh.
Ngwe, let's do it in stages.
Yeah.
Otherwise, we're going to be all over the place. Let's start off with paragraph 21.4.
Yes, Chair.
You call that the first transaction.
Just
Oh,
mention
sorry.
again
SS3.
which bundle so that the reader of
sorry.
the transcript
As
will
you
know.
choose. Bundle B, SS3B, Mr. Chairperson, and at page 359.
359.
Yes.
Oh, no, I was looking at, is that B as well?
Yes, there's a B1 and a B2, Chairperson, because the Siangena papers are about 400
Well,
pages.
this one has B, so it doesn't say B1 or B2, and this one is B2.
I'm going to attend to your files.
Yeah, will you change that quickly to make sure? B2 is supposed to be the ones that says court applications continued.
That is.
Yeah, will somebody just check these things so that we don't have to always keep on having to correct? So the bundle in which court applications commence will be marked as bundle B1.
Yes.
And the bundle or the lever arch file in which court applications continue will be marked as bundle B2.
Yes, as you wish.
Yeah, let's get this sorted out.
Yes.
Okay, at page 359.
359, Chairperson.
Okay.
So, at paragraph 21.4, Ms. Ngoi, you deal with the first transaction.
Yes, Chair.
If you could tell the chairperson briefly what the concern is relating to that transaction.
Well, Chairperson, in this transaction, Mr. Montana, this relates to a property in Parkwood. Mr. Montana had purchased that property in 2014 for 1.8 million. He then sells the property to Precise Trade. Now, Precise Trade is a company where one of the directors of Precise Trade is the lawyer representing Siangena, Mr. van der Walt. So, you know, the issues of conflict arise in that regard. But also in respect of this property, it was valued at just over 3 million.
He bought it for 1.8 million.
850 million, yes. And then he sells.
I'm sorry.
It's
He bought it
21.5.
for
Chair.
1.850 in July 2008, is that right?
On the 4th of July.
4th of July 2008.
2008.
Yeah.
He pays that.
And then
for
you
the
say
property.
he sold it
For
in
6.8.
2014.
Yes. For
Yeah,
6.8.
continue. To the attorney who represented Siangena.
Yes, the company, Precise Trade is a
Or
company.
to a company.
That's right. Where he is a
yes.
director.
Yes.
Yes.
Okay, continue.
And the purchase price was 6.8.
Yes, so that would have been
There was a profit
about
of
6
4.
years after he had bought it.
That's correct, Chair.
Yeah,
Yeah.
okay.
The profit for that amount was.
And the amount was 6.8 now.
Yes, Chair.
That was, he made quite a good deal.
Profit.
Huh?
4.95 million, Chairperson.
Yes, over 6 years.
Yes.
Yes, and I think you were saying you wanted to tell me what the value of the property was.
The market value at the time was, the market value of the property at the
Yeah.
time was 3.3 million.
3.3 million.
Yes. So Precise Trade bought it for much more than what, was the
Yes.
market value.
Yes.
Yes.
And this was 5 May 2014.
That's correct, Chair.
And what was, and the addendum was April 2014,
That's correct, Chair.
when he signed the addendum, they signed the addendum.
That's correct, Chair.
And that's the addendum that
We don't know
you
anything
could
about.
not, Prasa's people could not find, didn't know anything about.
That's correct, Chair.
And you can't remember if there was a witness from within
No, I can't
Prasa.
recall, Chair.
From within Prasa.
Yeah.
Okay.
So if I can just, so to identify who Mr. van der Walt was, please look at SS3B, page 360, bundle B2, SS3B, page 361, paragraph 21.10.
I'm sorry, I was still trying to look for the
Oh,
name of the purchaser in paragraph 21.5. I can't see the name.
Yes,
You
Precise.
did mention the name of the
It's
company,
Precise.
but I can't see
Precise
it here.
Trade, Chair.
It's
Is it in here?
6 lines from the top of
Oh,
page.
Precise Trade,
Precise
yes,
Trade,
Yes.
okay.
Chairperson.
Thank you. And you said one of the directors,
Was Mr. van der Walt.
Mr. van der Walt,
Yes.
who was representing Siangena
Yes.
in its transactions with Prasa.
Yes, Chair.
Okay.
And if you could go to paragraph 21.10, you identify exactly Mr. van der Walt's role.
That's correct, Chair. So at the time of this particular transaction, what is reflected in 2110 indicates that Mr. van der Walt was the attorney for Siangena, and Siangena was performing work on the phase 1 project and bidding, to be appointed to phase 2. So he was involved in advising Siangena at the time that Siangena was doing
Both in
work.
phase 1 and phase 2.
That's correct, Chair.
Yes, and you say he was the sole director of
Of the
Precise
company.
Trade.
Yes, Chair.
Is that right?
Yes.
Oh, yes, okay.
Now, in the review application, who represented Siangena?
In the review application, we had a Mr. van der Merwe, I think, Gert van der Merwe, representing Siangena.
Was Mr. van der Merwe from a different law firm? Or was it the same law firm?
I don't know if they were together with Mr. van der Walt, but what I know is that Mr. van der Merwe was the attorney and has been the attorney of Siangena.
Was, when you say he was the attorney for Siangena, and you say you don't know whether
They were in the
he
same
was from
company.
the same law firm, in terms of correspondence, do you remember whether there was a change of law firms in regard to the interdict, whether PRASA began to get correspondence from a different law firm or not?
No, the law firm that has always represented
Remained the
Siangena
same.
was, yes, represented by the lawyer, Mr. Gert van der Merwe.
And you, Mr. van der Waalt, or van der Merwe, did you say van der Merwe?
Van der Merwe was the
Yeah,
attorney.
yeah.
Van der Walt was involved,
Yes,
in assisting Siangena, but was
Mr.
not the attorney.
Mr. van der Merwe
Yes.
was an attorney and was not counsel in the interdict, or is that something you are not sure about?
In the interdict,
Uh-huh.
it was Mr. van der Merwe
Yes.
that represented Siangena
As counsel or as an attorney?
as the attorney,
As the attorney.
as the attorney, Chair.
Oh, okay, but you say the correspondence remained with the same law firm?
That's correct, Chair,
Okay.
even to date.
Okay.
Then the second transaction you deal with at paragraph 21.12 on that same page, page 361. Will you tell the chairperson very briefly what that transaction was about?
This was a,
Paragraph 21?
21.12, chairperson.
12.
Yes.
Okay.
this was a sale of property at Waterkloof, Pretoria, Chair.
And what was the purchase price?
The purchase price was 10.5 million.
And who was purchasing? Was it Mr. Montana?
Well, in terms of 2115, Chair, we reflected that the purchase price was 10.5. The purchase price had to be paid in cash.
10.5 million rand.
Yes, it had to be paid in cash into
was
a trust
paid in
account.
cash.
Yes, into a trust account of Van Rensburg Inc. attorneys upon signature of the contract. So they were the ones that were doing the conveyancing of the transaction. This particular contract lapsed because Mr. Montana failed to pay the purchase price.
Yes.
Yes, but then if you look at paragraph 21.16, the last sentence there,
In relation to the same property, yes, Mr. Montana then agreed to pay a non-refundable a deposit of 3.5 million, which was subsequently paid.
and then 21.17 tells you who the sale agreement was between.
Yes. So the sale agreement, Chair, was between Anmani, represented by Mr. Beer, and a minor property trust represented by Mr. Johann Smith, a trustee. The beneficiaries of the minor property trust are the children of Mr. Montana. So the purchase price was 11 million.
It went up from the 10.5 million that had originally been the expected purchase price.
Okay. I'm getting confused. Initially, well, there was a reference to 10.5 million rand being a purchase price, and then you said that agreement fell through because Mr. Montana failed to pay the purchase price, but he had agreed to pay a non-refundable deposit of 3.5 million, which was paid.
That's correct, Chair.
And now, paragraph 21.17 talks about 11 million and a sale agreement. Is that in regard to the same property?
That's correct, Chairperson.
So there was a new agreement?
Yes.
Okay. The previous agreement had been between Mr. Montana and the seller, and this one involved trust.
Well,
You are not sure about that?
Well, this one was the purchaser became the trust.
Yeah.
And what we found out was that trust belonged to Mr. Montana's children.
Yes.
So the connection that is made is that,
Yes.
it was in relation to him.
Okay. And was there a deposit to be paid for this?
The 3.5 he paid on 2118, Chairperson, on page 363, we indicate that the balance of the 7.5 million was paid by Precise Trade.
Hang on one second. But am I right to say the 10.5 million was the subject of a certain agreement which involved Mr. Montana as one of the parties?
Yes, Chair.
That lapsed,
It lapsed because he couldn't raise the
and
funding.
he had paid 3.5 million that was not refundable.
When it was revived, the transaction was
Or was
revived.
it paid when a new agreement was entered into
Yes.
in regard to the same property?
That's right.
But now, not with Mr. Montana as such, but with a trust, with his trust,
With the children's
where the
trust.
children were beneficiaries.
That's correct, Chair.
And, but was that so he paid the 3.5 million when they had to deal with the second with the agreement involving his trust?
That's correct, Chair. Remember, the first agreement was for 10.5,
Yes,
and then this one
was for
went
11
up to
million.
11, yes.
Oh, okay. So, but then 21.18 you says the balance, I guess the balance after the 3.5 million.
That's right.
The balance in an amount of 7.5 million was paid by Precise Trade. Mr. Smith then requested that the contract be altered to reflect Precise Trade as the purchaser. Okay, talk to me about that.
Chair,
What's happening there?
these issues are very complex, Chair, and I'm going to stick to what is contained in the founding affidavit. So what, if you recall Precise Trade, one of the directors in Precise Trade is an attorney for Siangena. Yes,
Mr. van der Waal.
that's correct, Chair.
Yeah.
Now, when this particular transaction happens, Mr. Montana can only raise 3.5, non-refundable, he accepts that. It becomes bizarre that the balance of the transaction is paid by the Precise Trade entity, where, you have the lawyer for Siangena
Yes.
being, the sole director paying the balance of
Yes.
this price.
Yes.
So, I mean, when you look at it, and then also, there's then a request to have the property now, the purchaser being changed to Precise Trade.
Yes.
Mr. Montana pays 3.5.
Deposit, yeah.
Yeah, and then, the balance is paid, and that company was, the property was intended for his beneficiaries. But now, Precise Trade takes over this transaction and completes it, and it is then registered as the purchaser.
So ultimately, it was registered as Precise Trade's property.
That's correct, Chair.
Okay, and I see this was happening in 2014.
That's
Was
correct,
the
Chair.
end of the year.
Yes, Chair.
Yes, Mr. Soni.
2119, Chair, we indicate that on the 26th of November 2014, Ms. De Beer met Mr. Montana at the property. Mr. De Beer and Mr. Montana did the walkabout, and the keys were handed to Mr. Montana of that property where Precise Trade had paid the balance.
And a property that was that was now registered in the name of Precise Trade.
That's correct, Chair.
The key was handed over to
To
Mr.
Mr. Montana, yeah.
Okay.
And just for completeness sake, in paragraph 21.18, there's a reference to Mr. Smith. Who was Mr. Smith?
I can't
He was
recall.
the trustee.
I
If you
think-
look at,
Oh, yes.
In the
he-
previous page.
Yeah, in the previous page, he was a trustee of the Children's Trust.
Chairperson, have you got a reasonable picture of the second transaction now?
Yes, I think so, insofar as one can get. Yeah, so it starts being, it starts with a situation where the purchaser is Mr. Montana's trust, and the beneficiaries of the trust are Mr. Montana's children.
Children, yes, Chair.
And Mr. Montana pays 3.5 million
Yes,
rand
Chair.
as a deposit. And then an arrangement is made in terms of which a Precise Trade
Pays
pays
the
the
balance.
balance of
Yes, Chair.
7.5 million. And it gets registered in
In Precise Trades.
Trade's name.
Correct, Chair.
But on the 26th of November 2014,
The
the
keys are
keys
given.
for the property are given to
Mr. Montana.
Montana. Now, who knows this?
This was
Who
picked
knows
up.
that this is the position?
This was picked up by the investigations, Chair, when the
Yes.
forensic investigations was done, and there was a follow-through on these transactions. It revealed that
Yes,
this is
no,
how
what
they
I want,
happened.
but what I want to know is, how do they come across? Is it because they interviewed Mr. Beer and got a statement from her? Is it because they came across a letter in some file where somebody refers to the fact that Mr. Beer and Mr. Montana had a walk-through inspection and that Mr. Beer handed Mr. Montana the keys? That's what I want to find out.
Chair, as part,
Because unlike the transactions, the purchase agreement that can be found in documents,
Yes.
who the purchaser was, what the deposit was, who has this knowledge, personal knowledge of this?
Mr. Chairperson, can I don't want to give evidence, but I thought if I could
Yes.
assist,
Yes.
it will shorten
Yes,
the inquiries.
yes.
In the answering affidavit, Siangena deals with these matters, not in detail. And I'm going to take the witness to those, to their answers. But in addition, Mr. Montana files an affidavit which is not part of the papers. So we will look at that to see what his answer is to each of these allegations.
But well, if this is taken from a certain affidavit, then it's fine if I'm told it is in somebody's affidavit.
Yes.
It is.
No,
There's
it is part of the
21.19.
investigation, but the point I'm trying to make, Chairperson, is that we do have Siangena's versions on these matters.
Yes, yes.
And you will see that the dispute is quite narrow in respect.
Yes. Okay, maybe let me go back to you as a witness, because this is your affidavit.
yes, Chair. It's
You
a
say
difficult
on this
affidavit, I
date-
must say.
You say on this date, Mr. Beer met Mr. Montana at the property.
Yes,
Mr. Beer and Mr. Montana carried out a walk-through inspection of the house, and Mr. Beer handed the keys to Mr. Montana.
yes,
Now, this is quite important
yes, Chair.
in the light of the fact that you have just told us that the house was registered in Precise Trade's name
Yes, Chair.
after initially the purchaser had been
Mr. Montana.
Mr. Montana, or his trust.
His trust, yes.
Trust. So now, do you have personal knowledge of this?
No, Chair,
You
not
don't
personal
have-
knowledge.
Yes.
This is what, was part of the
Is
investigation.
this what
invest-
is in records that PRASA has
That's correct, Chair.
that came from the investigators?
Following the work that the
Yes.
investigators have done.
But do you know what their source of information was?
The investigators went out, Chair, to interview, the various people that they picked up as being people who were mentioned in the documents that they found in relation to the properties. So that work allowed them to be able to approach different individuals and ask them exactly what transpired.
Okay. It's not satisfactory.
No, I understand perfectly.
So I need somebody to check what was the basis on which the investigators said on this date, Mr. B met Mr. Montana at the property, and Mr. B and Mr. Montana carried out a walk-through inspection of the house, and Mr. B handed the keys to Mr. Montana.
Yes.
And I guess Mr. B, whoever she is, can be interviewed or may have been interviewed to say what does she know about that.
Yes, Chair.
Yeah.
Yeah. Chair, I'd like to say, because I'm the deponent of this, and obviously some of the information was communicated to me, so I don't have direct knowledge of some of the issues here, and it will be dealt with accordingly, by the lawyers in the matter before court.
Yes, no, you may have said at the beginning of your affidavit that you're not relying on your personal knowledge.
That's correct.
And you rely on some records, but if you were able to say, I said this here because in the records that we
There's
have
a
at
document.
PRASA, I came across a statement by Mr. Pierre or Mr. Montana that said this, then I would understand that.
Yes.
Yeah.
There's copies. There's annexures, Chair, to the document that indicates, email correspondence that was picked up through the investigations. Yes.
Is it a conclusion that you reached based on
those emails?
Yes. On emails exchanged between who and who?
Mr. Beer.
And
yes, Mr. Montana. Yes.
Those are within the records of PRASA.
That they are.
That's the first thing to look for and to make available. But apart from the emails, I think Mr. Beer should be approached for an affidavit.
Yes.
Yeah. Okay. Thank you. It's just that it's very strange because now the keys get given to
Mr. Montana.
To Mr. Montana at a time when, in terms of the documents, he is supposed to have nothing to do with this house.
That's correct, Chair.
Previously, if it was at a time when the purchaser was the trust, then one would understand.
That's correct.
But it has been suggested that precise trade should be the purchaser.
Now it is the purchaser. That's correct, Chair.
Now one expects somebody from precise trade to receive the keys.
That's correct,
and
Chair.
not Mr. Montana.
That's correct, Chair.
Okay. All right.
Then at paragraph 21.22, you deal with the third transaction. And where is that property situated?
This transaction is a property in Sandhurst, Chairperson, 199 Empire Place in Sandhurst.
I'm sorry, just to round off the second transaction. As these things were happening, buying of property, deciding who is going to be the purchaser, Mr. Montana's trust or precise trade, or who Siangena was continuing to do work for PRASA.
That's correct.
Is that right?
Yes.
Okay.
And just again, in context, that was ended in 2016 or 17, Ms. Ngoyi. That's when the interdict came. When
Yes,
told
that's
them
when
to
the
stop.
interdict, that's right.
So 2014 certainly
Was in the process. where Siangena was doing work for PRASA.
Now, in relation to the third transaction, starting at paragraph 21.22, in the third sentence of that paragraph, you set out where you got this information from.
Yes.
Will you tell the chairperson where this information is from?
So in relation to the Sandhurst property, Chair, the facts relating to this transaction were contained in a sworn statement by a Mr. Louis Green, an estate agent that was employed by Pam Golding Investments, who was instructed by Mr. Kola to sell the property in Sandhurst during about the middle of 2014. So that statement is attached to the papers that are in court.
Yes.
We will obviously get a copy of that statement. Now, in brief, what was the issue in regard to this property?
Mr. Montana made an offer to purchase in Sandhurst in the amount of 13.9 million.
And this was, you say in paragraph 21.23,
Yes,
in regard to this property, on about 26 October 2014, Mr. Montana visited the show day. Well, you start by saying the Sandhurst property had been placed on show on several occasions.
yes,
On about 26 October 2014, Mr. Montana visited the show day and expressed an interest in purchasing the aforesaid property. You say Mr. Montana made an offer to purchase the Sandhurst property in an amount of 13.9 million rand.
that's correct.
The offer was accepted by the seller on 28 October 2014.
That's correct.
Yes, okay, continue.
Yes.
And then what happened next? That's contained in paragraph 21.24.
So on the 6th of November 2014, Mr. Green received an email from Mr. van der Walt. Mr. van der Walt is Precise Trade. A letter from...
Mr. Green again, that's the estate agent.
That's correct. From Pam Golding.
From Pam Golding.
So he receives an email from Mr. van der Walt. And the letter is also attached, Chairperson. There's a number of emails that are also attached to the affidavit. In the letter, the attorneys confirmed that they had 5 million rand in trust, in a trust account with Investec Bank.
Yes.
And on the 7th of November, Mr. Green received a further email.
Hang on one second. This Mr. van der Walt, is that the same as the attorney for Siangena?
That's correct, Chair.
So the estate agent, in regard to the Sandhurst property, receives an email from Mr. van der Walt on the 6th of November.
That's correct, Chair.
And then there is a trail of emails. And in the letter, Mr. van der Walt confirmed that they had 5 million rand in a trust account with Investec.
That's correct, Chair.
Yes, continue.
So on the 7th of November, so effectively this transaction was dealt with, between...
I'm sorry, I think let's go to the emails because I want to know what was the letter saying, apart from, or is that all that it was saying? That they had that 5 million rand in that account?
In the trust account, yes, Chair.
Is that the important thing it was saying?
Well, yes, that's what we thought was important to reflect,
okay,
Chair.
all right.
So on the 7th...
But what I'm wanting to connect is, who is he acting for now when he writes to Mr. Green, Mr. van der Walt?
Our view is that he's acting for Mr. Montana.
Yes. Does it say in the letter, in the email or not?
Well,
do you remember?
I can't remember if it says, but if you look at the interest was shown by Mr. Montana at the time,
Yeah.
in relation to this property. And when you look at, what was happening during the transactions with Siangena at the time, what became bizarre was that the attorneys now of Siangena were, assisting Mr. Montana in concluding these transactions.
Well,
Do we have these emails here?
we don't have them here, Chairperson.
Uh,
But but they are attached to, or I mean,
To
they're
the papers.
annexed to the founding affidavit. And we'll
Yeah, they are necessary because these bits and pieces, they can become very important,
Yes.
you know. But you say you don't remember whether in that email Mr. van der Walt does say expressly who he is acting for.
No, I don't recall, Chair.
You don't recall?
No.
But what do you say in paragraph 21.25?
There's another instruction on 2125 on the 7th. Mr. Green received a further email from Mr. van der Walt, to which was attached a proof of payment. So Mr. van der Walt sends this email to Mr. Green into a trust account of Pam Golding for and on behalf of Mr. Montana. So in the first email, I was alluding to the fact that I'm not sure that he mentioned that he was acting on behalf of Mr. Montana. But when the payment was made, he then reflects that it is made on behalf of
became
Mr.
clear
Yes,
that-
it becomes
yeah.
clearer now that he's acting on behalf of
Okay.
Mr. Montana.
Okay.
So there's attaching the proof of payment.
And then what happens next?
And then on the 25th of November,
You didn't get a copy of the agreement in regard to this one?
in relation
I
to
see
this
there has
property.
not been a reference to an
No,
agreement.
no.
Okay, yes, all right.
And then again, in the same month, Chairperson, on the 24th of November, Mr. Green, the estate agent, received another letter from Mr. van der Walt, confirming an instruction from his client, Mr. Montana. So it becomes clearer now that Mr. van der Walt is also acting for Mr. Montana, where Mr. Montana has asked that the buyer be changed to precise trade.
So, so in regard to this transaction, the idea that the purchaser should be precise trade emerges
From Mr. Montana.
again.
Yes, it does.
Yes. And now Mr. van der Walt says that comes from Mr. Montana.
That's correct.
In regard to the second transaction, it was said to have come from Mr. Smith,
Yes.
who was a
Who was a
trustee
trustee.
of Mr. Montana's trust.
That's correct, Chair.
Okay.
Just on the question of Mr. Montana's interest in this property, would you read what paragraph 21.29 says, Ms. Mbui?
Mr. Montana continued.
Oh, sorry.
I'm sorry. Well, that last sentence of paragraph 21.26 seems important.
Yes,
Yes, do you want to deal with that?
yes.
And the last sentence of paragraph 21.26.
So the letter
Yes,
drafted by Mr. van der Walt
yes.
instructed Mr. Green, who was the estate agent, to allocate the deposit paid on behalf of Mr. Montana to precise trade.
So the situation is that Mr. Montana visited the property during one of the show days, liked it, subsequently made an offer which must have been accepted, and he paid an amount of 5 million rand.
Well, what we're told, Chair, is that that amount, the attorneys, van der Walt,
Yeah.
is the one that confirms that that amount was sitting in their trust account.
Yes, yes. So, but what I'm saying is, this amount is paid either on his behalf or by him, but it goes via van der Walt.
That's correct, Chair.
Attorneys.
That's correct.
But at that stage, the payment is being made on behalf of Mr. Montana because he's going to purchase the property.
That's correct, Chair.
And then later on, Mr. van der Walt says Mr. Montana has said the purchaser should be Precise Trade.
Correct, Chair.
The company whose sole director is
Mr.
van der
Van Walt.
Walt.
That's correct, Chair.
And the same company that,
Had
in
been
regard
doing
to the
work.
second transaction, had taken over
That property as well,
that
Chair.
property as well.
Yes.
And then now Mr. van der Walt says to the estate agent, that 5 million rand that they had already paid it, or no?
Yes.
That they had paid already to
Yes.
the estate agent. It should now be been taken as a deposit for Precise Trade.
That's correct, Chair.
Okay. Uh,
It is not something one comprehends unless one reads it over. and
Yes,
over
yeah,
again.
you've
Yeah,
got
Chair,
to
you gotta go
try
through
and
it.
follow it, yeah.
Yeah, you have to go through it over
Yeah.
and over again Chair,
Yes.
to understand what actually happened.
Okay.
And then at paragraph 21.28, you'll see that there is a reference to the seller, Mr. Kohler,
Yes.
and his communication with Mr. Montana. Could you please read that into the record, Mr. Ngoyi?
So now the property was signed on behalf of Precise Trade, but Mr. Koller, the seller, right, addresses an email to Mr. Montana asking him to indicate whether he had any interest in taking occupation of the property before transfer.
When does this happen in relation to the finalization of the transaction? In
The
other
sale
words-
of the property.
Yes, yes. Is that around the time when Mr. van der Walt writes and says, take that 5 million rand to be a deposit from Precise Trade, or is that months later?
No, it's in the same month, Chair.
It's about the
It's
same
in the
month.
same
2
month.
days later.
Yeah.
Chair, that's
Okay.
it. You see 21.26.
Okay, I think what happened is that you went much ahead of me.
Sorry, Chair.
So the full purchase price was 13.9 million for this property.
That's correct, Chair.
Yes. Let me just have a look here. Oh, that is quite interesting. Yes, 21.28.
Yes.
So Mr. Kohler was the
Was
seller.
the seller.
He writes to
Mr.
Montana in an email asking him to indicate whether he had any interest in taking occupation of the property before transfer.
Yes.
So he's wanting to see whether, so that if he wants to come in before the transfers are
Specific.
done,
Yes,
they
Chair.
can talk about occupational interest and
That's
so
correct,
on.
Chair. Yeah.
Okay, and then?
So Mr. Montana continues to be involved in the transaction.
No response is found in the emails to this letter, to this email from Mr. Montana.
Well, he continues to get involved in the transaction, so there was an email.
Yeah,
For example, the email address, Mr. Montana, that was used was stipulated as a contact for the transferee. So there was communication between the seller and Mr. Montana. In addition, because the conveyancers obviously would be acting on behalf of the seller in this regard. So that communication was happening where Mr. Montana was involved. In addition, the conveyancers addressed regular progress reports to Mr. Montana. And these documents are also available in the founding affidavit, Chair.
I think what will be necessary, Mr. Soni, is that all these annexures that are not here but are somewhere, they will need to be made available, and there needs to be something that tells whoever reads here where to find them.
Yes.
Yeah.
Chairperson, what I am going to propose, subject to your approval, is we have a special set of documents relating to all these transactions, with all the annexures there, and just a summary of what each of those transactions entail.
Yeah. No, that's fine. And it may be, it may be that some way needs to be found to have something on each page where an annexure is referred to, which
Yes.
says if you want to see that, go to
It
that
goes
page
to
or
this,
that
yes.
bundle.
That
It's
is-
page whatever.
Yes.
So that, because when you read, you immediately want to look
To go to the
behind,
annexure. Yeah.
you know, and you are disappointed when you don't find it.
That's correct, Chair.
Yes.
Yeah. Okay, all right. I see we are at
At 4
3 minutes
o'clock, I was
past-
just going
4
to
minutes
tell you,
past 4.
Chairperson.
I think we both underestimated how
The-
long we
yes.
would take.
Yes.
I thought we would finish before lunch,
That's
but
what I thought, yes,
no time has been wasted. It's all been very important
absolutely.
evidence. Now, how far are we from finishing with her?
Chairperson, can I just say that it's just the one more transaction after this, and then Mr. Ganscher's transaction. But what
There is
I-
still that first affidavit or not?
we had decided, Chairperson, that we will deal with that in the second phase. And the main reason is, it is a matter in which Ms. Koyama has a major interest. Maybe we should
Yes.
just
Okay.
have all of that evidence.
Yes.
It's a very self-contained thing.
Yes.
And one would be able to deal with it in about 2.5 hours in all.
Okay.
You know, rather than dealing with it in stages.
Okay, so to finish here, you need about how much time for today?
About 20 minutes.
About 20
Chairperson.
minutes. No, that's fine. Ms. Ngoye, you can still stay?
I can, Chair.
Yeah, okay, all right. I think Council 4 is also all right. Okay, I think let's take a short break and then we come back and then we'll continue and then we'll finish.
Thank you, Chair.
We adjourn. Okay, let's proceed.
Where is error?
What, 21.30? 31. So the signed,
Your mic is off.
My learned friend wishes to be excused because it doesn't involve his client directly, Chairman.
Thank you, thank you.
Sorry, Ms. Ngoyi, I just wanted to
that's okay.
be collegial to a colleague. We were talking about the property being transferred to precise trade.
Yes, Chair.
Now, that happens on the 6th of March. What happens on the 12th of March?
I'm sorry.
I'm sorry, Chair.
Are you deliberately skipping 21.30? Seems important.
Oh, as you please, Chair. I in fact intended to deal with it earlier. I intended to deal with it earlier before we broke, and yes, sorry.
Yes, okay.
Would you please, Ms. Ngoyi, read into the record an email that Mr. Montana addresses to the seller of the property on the 3rd of February 2015?
Yes, Chair.
That's at paragraph 21.30.
That's correct. He says, we were not aware of the delays in the payment of fees.
I'm sorry. I think just start from the paragraph itself on 3 February 2015.
Okay. So, on 3 February 2015, Mr. Montana addressed an email to Mr. Collar regarding the payment of the transfer costs in respect of the property. A copy of the email is attached, Chairperson, to the documents before court. In the email, Mr. Montana said that we were not aware of
and you are quoting now. You are
that's correct.
from,
I'm quoting. Sorry, Chair. I'm quoting in inverted commas there. We are not aware of the delays in the payment of fees and the consequent breach of contract. I'm aware that our attorneys were busy with the VAT registration of the trust. This may have contributed to the delays. I have asked the attorneys to abandon the VAT registration for now and ensure transfer is concluded immediately without further delay. I have discussed the matter with our attorney, Mr. Rian van der Walt, who has since been in contact with Talita. He made an undertaking to settle the fees by today or latest tomorrow morning. Close quote.
So what does that indicate in relation to Mr. Montana's association with the property?
Well, effectively, Chair, he must be the person concerned, obviously, in relation to, this particular transaction, because he seems to be taking over. He's involved in the communications that are happening even with the estate agency. But also what is interesting is that he keeps referring to the attorneys, Mr. van der Walt, of having to settle the payments for him. So that's what one can deduce from this.
And when he refers to the attorneys, in what capacity are the attorneys acting in relation to this property, according to Mr. Montana's email?
Well, they're his attorneys.
So the reference to our attorneys there in the email, you say is a reference to Mr. Rian van der Walt.
That's correct, Chair.
Yes. Who is the sole director of Precise Trade.
Trade.
And, yeah, okay. Mm-hmm.
But nevertheless, on the 6th of March, that property is transferred. But to whom is it transferred?
It's transferred to Precise Trade, Chair.
Now, after that transfer, to whom is communication relating to the property addressed?
It's addressed to Mr. Montana.
Will you just indicate what the nature of that communication is?
Paragraph 21.32, Chair, on 366. We talk about, on the 12th of March 2015, the sellers of the Sandhurst property addressed an email to Mr. Montana. The email was attached to the documents as well that are before court, Chair. It says, in quotes, "Hi, Lucky."
No, sorry, can I ask you to read whom the email is addressed to?
The email is addressed to Mr. Montana.
No, please read it. If you read it right
The
on top of-
salutation.
Sorry, I'm not with you,
Page
Councillor.
367, right on the top.
At the top.
Yes, I was going there, Chair.
Okay.
It says, "Hi, Lucky."
And who in this context would Lucky be?
Lucky is Mr. Montana.
That's his name.
That's correct, Chair.
Yes, okay. Continue, read.
It says, "I called Eskom today to let them know we have sold number 199 and
119.
119, and to try to transfer the electricity account out of Janet's name. However, the process seems to need both parties. We need to give Eskom a move-out instruction to terminate our account, and then the new owners need to give them the move-in instructions to activate the new owner's account. However, when we give them the move-out instruction, they will cut off the electricity supply until the move-in order is given. I obviously don't want to leave you without electricity. The pond and the wine cellar are linked, and the wine cellar needs power to pump out water and prevent flooding. Would you please let me know as soon as you are able to do the account transfer with Eskom so that we can coordinate the instruction to happen on the same day?"
So this is after the property has been transferred to Precise Trade,
That's correct, Chair.
and the sellers are now talking about logistics in terms of moving out and making arrangements with Eskom to ensure that they are not billed for the electricity when they no longer live in the house.
That's correct, Chair.
And they send an email to
To
Mr.
Mr. Montana.
and not to Precise Trade,
That's correct, Chair.
and not to Mr. van der Walt, who
That's correct,
is
Chair.
the sole director of Precise Trade.
That's correct, Chair. They speak
And
to Mr. Montana.
They talk to Mr. Montana on the basis that they understand that he is the person who is going to be living in the house.
That's correct, Chair.
Okay, all right.
And then what's the next communication, Ms. Ngoyi? That's at 21.33.
So on the 19th of March 2015, Mr. Louis Green addressed an email to the seller of the centered property regarding the repairs to the gate motto, the security cameras, and the transfer of the electricity account. And once again, that email is attached to the court papers, Chair. We'll make that available.
And Mr. Green is who?
Mr. Green was the
Estate agent.
the
Estate agent.
That's correct. So he says, Mr. Green, he writes to Janet, and I quote, Chairperson, he says, "Hi, Janet. I chatted with Lucky being Mr. Montana, regarding the repair of the gate motto, the security cameras, and the transfer of the electricity account. He has confirmed that the appointment at 9:30 on Friday, the 20th of March 2015, and has requested they only attend to the gate motto. He will, at his expense, reinstate the security video system. he has also requested that you hold off as far as the transfer of the accounts is concerned. He is extremely busy at the moment and undertakes to pay all that is related to the bills until the transfer has been done. He has indicated that should he be able to attend to it within the next few weeks, that he should be able to attend to it within the next few weeks. Your indulgence in this regard would be much appreciated. Could you please advise who the gardening and pool services companies are, as he would like to continue with their service? So this is what obviously Mr. Green relaying this information to yes.
Now, in the next paragraph, there is a further reference to Mr. Montana's involvement with this property. Will you briefly tell the chairperson what that is?
This is 21.34.
Yes.
So a further thread of emails, Chair, relating to the Sandhurst property transaction is attached to the founding affidavit. In particular, I wish to draw attention to the email addressed by the seller to a pool service company dated 31st March 2015, in which it said, and I quote, "Hi Bram, this is just to confirm that we have notified the new owner, Lucky, that the pool cover part has arrived and we are awaiting his instructions to carry out the repairs. We have also given the Pam Golding agent, Louis Green, your contact details so that they can get in touch with you directly if necessary." Close quote.
Now, at paragraph 21.35, you make an interesting observation.
Yes, Chair. So it will be noted that Mr. van der Walt, as the sole director and shareholder of Precise Trade and Invest, is not copied on any of the above mentioned emails. The emails are direct to Mr. Montana.
And when you say that, what do you intend to convey?
Well, effectively that, Mr. Montana at the end of the day was the person that the property was bought on behalf of.
So, in this last email you read, which is at the top of page 369, this is an email from the seller of the property.
Yes, Chair.
Addressed to, who is it addressed to?
To
The pool service company.
That's it, Chair.
And it's addressed on 31 March 2015. And it tells the pool service company that the new owner of the property is the person to whom he refers as Lucky.
That's correct, Chair.
And you say that person
Lucky is Mr. Montana.
Montana.
That's correct, Chair.
Yes, and he says to the pool service company, he's awaiting
Instructions.
Mr.
from-
Montana's instructions as to the carrying out of repairs.
That's correct, Chair.
Yes.
Yes.
Okay.
Now, thereafter, there follows a rather interesting communication. Would you tell the chairperson what that is?
So on the 10th of May, Chair, 2016, Mr. Green sent an email to Mr. Montana. In the email, Mr. Green...
This is now 2016.
This is 2016, Chair.
So that's a year, namely 2015 has passed
That's correct, Chair.
since these other emails.
Yes, Chair.
Okay.
So Mr. Green advised that the sellers of the Sandhurst property had found 2 extra keys for the electric pool cover.
I'm sorry. Yes, okay. That found 2 extra keys for the electric pool cover.
That's correct.
They say, Mr. Green sends this email to Mr. Montana.
Mr. Green sends an
Mr.
email.
Green sends it to Mr. Montana.
That's correct, Chair.
Yes.
Mr. van der Walt responded. A copy of these emails are also attached. He then says in an email.
Please read the email.
He says, "Hi Louis, please explain why you have CC Meneer L. Montana." I'm just thinking that MNR.
Yeah, that's Meneer, yeah.
That's Meneer. In this email, you are well aware of the fact, and as already explained to you last year, before the property was even bought by my company, that Meneer L. Montana has nothing to do with Precise or this property. Please refrain from this action in the future. This is confusing, Chair.
No, it's not.
Well,
Yes, continue, Mr. Son.
Yes, and I tell you why it's not confusing.
Yeah, no, it's not confusing at all.
But you then put some context to that, Ms. Ngoi, and that's at paragraph 21.37.
yes, Chair. So the papers in the previous application were issued on the 2nd of February 2016. The Sandhurst property transaction was mentioned in those papers. The above email was sent only after Mr. Montana was confronted with allegations contained in those papers, and 2 days before Mr. van der Walt deposed to the confirmatory affidavit. Yeah.
No, it's not confusing at all.
It's not.
Yes.
So,
Mr. van der Walt, now says to Mr. Green, the estate agent, what are you doing? What does this property have to do with Mr.
with
Montana?
Mr. Montana, yeah. I mean,
Yes.
And obviously, what you say at paragraph 21.37 appears to have prompted that email.
that's correct.
I mean, that communication.
That's correct. So when the application was made, you had to cover up there so that it's not obvious.
Yes.
Thereafter, we deal at paragraph 21.38 with the fourth transaction.
Yes, Chair.
And this involved a property in which suburb?
It's in Hurlingham, Chairperson. It's situated at 12 Montrose Road in Hurlingham.
And Mr. Green appears to be the estate agent again.
Yes.
Yes.
Yes, Chair.
Now, very briefly.
Mr. Green is the state agent here as well.
Yes, Chair.
Oh,
In 2140.
that is in regard to the fourth transaction.
That's correct, Chair.
And
So,
how far apart were these properties? Usually, estate agents are restricted to an area, isn't it? Or certain areas that are
Yes,
adjacent to one another.
They're not too far away, I know, because I stay near that
yes,
area.
they're not too far apart.
They ordinarily would have entailed two separate estate agents
Yeah,
belonging to the same company, but
Oh.
they're not too far apart.
okay. Okay, continue.
Yes, Ms. Ngoi.
so must I continue to
Yes.
40?
Yes.
So Mr. Green was mandated by Mrs. Gafisser to market and sell the Hurlingham property. So the property was placed on show, which Mr. Montana attended, on about October 2014. Mr. Montana, having viewed the property, immediately expressed an interest in purchasing the property. So on about 15 October 2014, Mr. Montana requested that the offer to purchase be forwarded to Mr. Smith,
Now, this is Mr. Smith,
who, the trustee.
the trustee.
That's correct, Chair. the minor property trust, his children's.
And
What is the value, what was the purchase price of this property? I'm trying
The
to look
purchase
for
price
it.
was 12 million. 12 million.
Oh, okay, that's in 21.41.
That's correct, Chair.
Okay.
So the minor property
I'm
trust.
sorry. The the second property was paid for through
Precise trade.
Mr. van der Waals.
Yes, precise
Is that
trade.
right?
That's correct, Chair.
That property was also paid,
Through precise.
the deposit of 5 million was said to have been paid by or on behalf of Mr. Montana through Mr. van der Waals.
That's correct, Chair.
And later on, when it was, the plans changed, say, Precise Trade must be the purchaser. Mr. van der Waals said that amount must be taken as Precise Trade's deposit,
That's correct, Chair.
which means if the 5 million had come from Mr. Montana, he would now be owed money by Precise Trade.
That's correct, Chair.
Yes. And then, of course, we see Mr. Montana being
The owner.
involved quite throughout and correspondence being
Directed
addressed
at
to
him.
him.
That's correct, Chair.
That's the third transaction.
Yes,
And that was 13.5 million.
that's correct, Chair.
Yeah, and the one before that had
Was 10. It
initially
was 11,
11
yeah.
million.
It was
And-
10.5 and then it went to 11
Yeah, it
million.
went to 11. So this one that we are dealing with here
It's
now, the
13
fourth
million.
one is 12
Yeah.
million.
I mean 12 million, Chair, not 13.
Yes, okay. All these purchases are happening in 2014, is that right?
That's correct, Chair.
Okay.
then at paragraph 21.42, the details of who signed the offer and so on are set out. Could you please summarize the position for chairperson?
So the offer was signed by Mr. Smith, the trustee, Chair, in his capacity as the trustee of the Minor Property Trust. However, both Mr. Smith and Mr. Montana represented to Mr. Green that the property was being purchased by Mr. Montana. And there's reference to correspondence to that effect, Chair.
And then what happens
And the
there?
offer was rejected by the seller.
And after it was rejected,
So on the 23rd of October 2014, the Minor Property Trust, through an email from Sarisa Davids, Ms. Davids, made another offer to purchase the Hurlingham property for an amount of 13.5 million. And once again, proof of that email correspondence is attached, Chairperson, to the papers before court.
now in the offer to the, by the Minor Property Trust, it was subject to payment of a deposit of 2.4 million rand and the purchaser obtaining a bond of 9.6 million rand. Is that correct? That appears at paragraph 21.41.
That's correct, Chair. That is correct. In 21.41, it says, so the offer was subject to payment of a deposit in the amount of 2.4, and the purchaser obtaining a bond of 9.6 million.
And when the offer was made for 13.5 million rand, what happened to the bond finance clause?
So that clause was deleted, Chairperson, and this is referenced in 21.44, which indicated that the offer was a cash purchase Furthermore, the sale was subject to payment of a deposit in the amount of 2 million. So the bond was no longer an issue here because there was cash available to purchase the property.
Well, you see, in paragraph 21.41, you say an offer of 12 million rand was made to the seller by Minor Property Trust represented by Mr. Smith. Was subject to a payment of a deposit in the amount of 2.4 million. And the purchaser obtaining a bond for 9.6 million. Okay, that offer was rejected. And then 3 days later, Minor Property Trust made an offer for 13.5 million rand. And that was a cash, that was to be a cash purchase.
That's correct, Chair.
And the important point is it's no longer subject to a
The
bond
bond.
being approved.
Yes, yes.
Then there is a development on the 3rd of March, Ms. Ngoyi. What was that?
A new offer to purchase was submitted where Mr. Montana was substituted for the Minor Property Trust as the purchaser.
Does this mean this offer of 13.5 million was rejected?
No,
We don't
Chair.
know.
So they make the offer of
Yeah.
13.5. But because it's a cash sale, you know, and the bond requirement is not an issue anymore. And one would surmise that in relation to that transaction, the purchaser would have been Mr. Montana. And that's why on the 3rd of March, 2015, they sign a new offer. Well, I suppose it's in relation to the same property, Chairperson, but they changed the
Yes.
name of the purchaser here to being the trust and not Mr. Montana.
Now, the new offer is for how much? Or is it the one
It's
at
the
21.47?
13.5, Chair.
It's 13.5, still
That's
that
correct,
one?
Chair. Yes, it's the same amount as
Okay.
what was offered here.
But the previous offer was from the trust.
That's correct.
Who is this new offer from?
The new offer to purchase was submitted by Mr. Montana.
So Mr. Montana is now substituted for the trust as the offeree.
Yes, what 2145 says, Chair, is that the new offer to purchase was submitted in which Mr. Montana was substituted for the minor trust property
And
as
then,
the purchaser.
now, in relation to this, to that offer, certain payments were made, and these are reflected in paragraph 21.46.
Yes, Chair.
What were those payments?
So on the 24th of March in 2015, Precise Trade, Chair, paid a deposit of 2 million rand into the trust account of Janine Bredekamp. The conveyancers attending to the transfer of the Hurlingham property. And there's proof of that.
And then in 21.47, there is still obviously an amount of 11.5 million rand.
Yes, Chair.
When is that paid?
So there were various delays, Chair, as reflected in 21.47 relating to the payment of the balance of the purchase price in the amount of the 11.5 million. And a copy of a letter between Mr. van der Merwe. Mr. van der Merwe is the attorney for Siangena. And
Van der Walt.
sorry, Mr. van der Walt, sorry. And Ms. Bredekamp.
Maybe Van der Merwe as well, but the one who deals with Siangena the most is Mr. Van der Walt.
That's correct, Chair. So Mr. van der Walt wrote, in quotes, he says, "We herewith confirm that we hold instructions from our client to confirm in writing that his delay in rendering a guarantee is not due to his malafides, but due to unforeseen circumstances pertaining to the sale of one of his properties, of which the profits out of the sale is earmarked to be utilized for payment of this property." That is the rendering of the guarantee. And he further on says, "It was conveyed to our officers that such funds will only be available during the last week of May 2015 to be transferred to our officers, whereafter our officers will invest the funds in an interest-bearing account with Investec to enable our officers to render a guarantee as stipulated in your letter of 30th of March 2015 through Investec."
And was that amount then paid?
Yes, the outstanding purchase price was eventually paid, Chairperson, on the 15th of May 2015.
Now, in your affidavit, in your founding affidavit in the review papers, you do not indicate that that purchase by Mr. Montana had actually been finalized. Because remember, Mr. Montana is now substituted as the offeree in place of the trust.
That's correct, Chair. That was his request.
Okay, but on the information at your disposal, that sale did take place.
Yes, that's correct, Chair.
And Chairperson, we will obviously make the necessary inquiries from our side to see who the owner of the property is on the official records. So those are the 4 transactions relating to Mr. Montana.
That's correct, Chair.
Now, there is one transaction relating to Mr. Gansha.
That's correct, Chair.
Now, could you explain to the chairperson in summary form how this took place?
Well, in 2011, Chairperson, Mr. Gancho approached a certain Mr. Murphy regarding a property that was situated in Durban, the purchase of that property in the Point Precinct in Durban. And Mr. Murphy had to post to an affidavit setting out the sequence of events that led to the sale of that unit. And a copy of Mr. Murphy's affidavit was also attached to the papers, Chair.
Now, Mr. Murphy had nothing, was he the owner of that property?
Well, Mr. Murphy had placed a unit including the furniture and fittings. I think he was the owner, Chair. Approached Mr. Murphy, if I recall.
Oh, sorry, it was owned by the Stafford Murphy Family Trust.
That's right.
But
so he was.
What was Mr. Murphy's role in that?
Let me just find it here, Chair.
I suppose, given the names, he would have been associated with the trust.
Well, yes.
Yes. What was the sale price of this property?
It was 3,050,000.
All right. Now that was placed on sale.
That's correct, Chair.
And what did Mr. Gansha do in relation to that property?
Mr. Gansha approached Mr. Murphy and indicated an interest in purchasing the property, Chair. Yes. As well as the furniture, some of the furniture that was in the property.
Yes. And did he visit the property, Mr. Gansha?
Yes, he visited the unit on several occasions, Chair.
And eventually the negotiations were concluded. What did Mr. Gansha do at the conclusion of those negotiations?
So Mr. Gancho, for the first time, informed Mr. Murphy that he was not, in fact, the purchaser of the property. Mr. Gancho advised Mr. Murphy that Mr. van der Walt would contact Mr. Murphy and provide further details.
Then what happened next?
So Mr. Murphy was then contacted by Mr. van der Walt, who advised that the purchaser was to be an entity called Grand Tower Trade and Invest 04 Pty Ltd. Mr. van der Walt is the sole director and shareholder of Grand Tower, and confirmation to that is attached to the papers, Chair, of directorship from the auditors of Grand Tower.
All right. So the sale was negotiated between Mr. Gancho and Mr. Murphy. Am I right?
That's correct, Chair.
And in regard to the payments, who made the payments?
The terms relating to the payments of the purchase price were negotiated and agreed with Mr. van der Walt, Chair, as a representative of Grand Tower.
And was there then an agreement that was concluded?
That's correct, Chair. So Mr. Murphy and the Grand Tower concluded the agreement for the sale and purchase of that unit and furniture and fittings. And the agreements are also provided, Chair. Copies thereof are provided.
So, in regard to, so we know now the property was not in Mr. Gancho's name, but in the name of Grand Tower.
Yes.
What is the link, though, that the investigations were able to establish between Mr. Gancho and that property on the waterfront?
The Mr. van der Walt being the link, Chair.
No. In relation to Mr. Gancho
Yes.
and the property. If you look at paragraph 21.56.
Yes. There was an email that was addressed by Mr. Gancho to the Reverend Marumo. And in that email, Mr. Gancho wrote, visit the following link for information on your accommodation. My apartment is C7 to 10. Enjoy every moment. If any questions or need anything, just call me.
What would that appear to indicate, that email?
Well, that effectively that Mr. Gancho, was the owner, because you don't lease somebody else's property, Chair, or invite people to occupy somebody's property if you are not necessarily the owner thereof.
Now, after the investigation started, was Mr. Gancho interviewed by PRASA or the investigator?
Yes, Chair.
And what did he say during that interview?
Mr. Gancho, in fact, on the 12th of August 2016, he says, you see, when I first saw the apartment...
Sorry, before I go into that, was the interview with Mr. Gancho recorded?
Yes, Chair, the investigators, and this was, obviously during the forensic investigation that was done by Worksmans.
And what you are now reading is what?
A transcript of the interview with Mr. Gancho,
Yes.
which was held on the 12th of August 2016.
What does he say there?
He said, you see, when I first saw the apartments, we were busy with our 2010 projects at the time. So at some point...
Sorry, the 2010 projects being what?
Would be those projects, those development of those stations, Chair, in relation to phase 1 of the project and the extension of the pilot phase.
Yes.
So he says, it says, at some point we would be made missing. Sorry, at some point we would be made missing our flights coming back because of the duration of the meetings and all that. One of the colleagues in Durban said, there are places here at the waterfront where people can stay. We used to sleep in different apartments there. It says, so we slept there, and at one point I went there with the family, and then we looked at the place. Then I got curious. I asked which one of these apartments are selling. Mr. Murphy said he is selling in that, I think it's C10. We went in there, we looked at it. If we came there on a Thursday or a Friday, we sleep over on Saturday, then we'll invite some of the guys we were with at the meetings. One of the guys who once went there is Mr. It doesn't show what I guess it doesn't reflect. It's not audible. I don't know his name. He says he is Alvin. He is from Siangena. In one instance, I think it was Mr. Mittelerkamp. So we really got interest in this particular apartment. And then I approached Mr. Murphy to say, I would like to buy this. Then this Alvin guy said he is also interested. Their company is also interested. And he said, you look very much interested in this. And I said, yes, I am, but I think it's too steep for me to be acquiring it. He said, okay, but do you like this flat? And I said, yes, I do. Then he said, okay, that's fine. And then I approached this guy, Murphy. I said, Craig, I'm really interested in this apartment. So we went in through the whole nitty-gritties of it. The next thing I heard Alvin saying, you can get that flat. Then when you are ready, said, okay, you can buy the flat and then we get it to be acquired by the company. He said, it won't be a problem for us as the company acquire the flat, and then maybe at some point when we are ready for it, we can talk. I said, okay, that's fine.
So, putting the whole, whatever he said in that interview in context, what seems to have happened?
What seems to have happened also here, Chairperson, is that Mr. Gancho was assisted in purchasing that property as well.
But the property was purchased in the name of Grand Canyon.
That's correct, Chair. He showed interest in the property, and yes.
And who was the owner of is it Grand Tower?
It does say.
Do we know?
I don't.
Isn't it?
Van der Walt terms, Chairperson, you will see that at 21.55.
5.5.
21.55, yes, Chairperson.
Grand Tower, yes.
Or Grand Tower. Mr. Van der Walt was a representative of Grand Tower.
Yes.
But is there something that tells us whether he was a director or just acting for them? Do we know whether
we can
Mr.
check
Van
that,
der Walt was a director of Grand Tower, or whether he was just acting as an attorney for them?
Yes.
We'll check that, Chair. I can't seem to recall.
Okay. But the transaction relating to Mr. Gancho, unless it connects with PRASA or somebody at PRASA, why would it be relevant? Or does it connect? Well, let me ask the witness.
Yes, Chair.
Yeah.
What we deduced from this transaction, the involvement of Mr. Van der Walt in assisting Mr. Gancho in obtaining this property, and also the fact that this was during that time where Siangena was really involved in the transactions of PRASA. And you'll recall, Chairperson, as part of the evidence that we gave was that Mr. Gancho was the one that was really pushing the transactions for Siangena to be concluded with PRASA. So a connection was then made, in relation to his participation in the Siangena transaction and the involvement of Mr. van der Walt in this respect.
How much was this last property again? The
That is
value of
three-
the purchase price?
About 3 million.
3 million, Chair.
About
3 million.
3 million?
Yeah.
Yes, but I'm not sure that I understand why it's relevant.
Well-
If it doesn't connect anybody from PRASA to it, or PRASA.
It connects Siangena, Chairperson, through Mr. van der Walt.
Yes.
Yes. So that's how, the way we interpreted this particular transaction was that was a form of gratuity that Mr.
Gancho.
Gancho was receiving in relation to his relationship with Siangena. So they assisted
But
him.
was he not part of, I thought he was part of Siangena.
No, Mr. Gancho is an employee at PRASA, Chairperson.
Oh.
Yes.
Oh, then I must have missed that part
Yes.
quite early.
Yes.
Oh, okay. Because he was the one who was asking Mr. Montana for approvals of certain. Okay, no, I think I got mixed up at some stage. Okay.
Yes, Chair.
No. Okay, so the theory is he's getting his share.
That's correct, Chair.
And you will see, Chairperson, at page 376, where part of the transcript is, it talks about a person called Alvin from Siangena.
I'm sorry, I'm at 376.
Yes, about 6 lines from the top, Mr. Chairperson.
Yes.
Says, I don't know his surname, he is Alvin,
Yeah.
he is from Siangena. And then about 4 lines later, he says, then this Alvin guy said he's also interested in the company, and he said, if you are interested, then we can get the property.
Oh, yes. Yes, okay. No. Okay, all right, thank you. Well, I see that Mr. Kancho was suspended in April 2014.
That's correct, Chair.
Was that after these transactions?
Yes, it was after the transactions,
After
Chair.
they were discovered?
Yes.
Okay. And ultimately, what happened to him?
Well, he was dismissed, Chair.
He was found guilty?
Yes, he was found guilty
Of
and
what?
dismissed of the misconduct.
misconduct.
In relation to
these
and-
these transactions.
That's correct, Chair.
Yes, and was his disciplinary hearing chaired by an outsider,
That's correct, Chair.
a lawyer?
Yes, Chair.
And we can get
Yes, we can get the
decision.
transcripts. Yes, Chair.
Okay, shall we do get that?
Yes.
Okay, all right.
Mr. Chairperson, may I then conclude this and I know I've overstayed my welcome here, Chairperson, but
Yes.
as you've pointed out, Mr. Chairperson, these are the small things that paint a rather clear picture of what probably happened at Ross. So, let me get back to your supplementary affidavit.
I see,
Ngoyi, sorry.
I see Mr. Soni. I'm not the only one who's poor with estimating time. I see that we are at 5 now.
I know.
The 20 minutes has
This
become
will-
40 minutes.
This
But
will take.
let's round off, it's
Yes,
fine.
yes.
Let's round off properly.
Yes. So you then make the point which we made earlier at paragraph 48 relating to the link between Siangena and Mr. Mudley, that Siangena paid 550 million rand to Hailway Trading, which shares the same address as Royal Security and was directed to Mr. Mudley.
That's correct, Chair.
2 other points that I want to make at this stage is,
When was that payment made? Do we know?
No, I don't have the date, Chair, but
Do you have the year?
no, I can't remember what year that is.
It's important because
Yes.
you know,
we
where
know
you
the-
place
yes.
some of these transactions may be important.
We'll find out, Chair.
Okay.
Now, you make the point that all these matters, including these property transactions, were reported to the police. Would I be correct?
That's correct, Chair.
And as far as you know, no arrests have been made and no prosecutions have been started.
No, Chair.
Now, the last point you make is that you have grave difficulty here and in the High Court in respect of the review application in regard to painting a full picture. Will you tell the chairperson in essence, what the difficulties were?
Chair, the challenges that we had in finding information at PRASA were grave because, the information was just not there, really. So we struggled when we took these papers to court. What we understood had transpired was that Mr. Montana had a special IT services employee who was really looking after his IT-related issues. Mr. Tusi, I'll get his surname now. His name is Utusite Moholelwa. He was one of PRASA's IT specialists. That's paragraph 52, Chairperson. Who it was found that he, on the instruction of Mr. Montana, had deleted information at PRASA on PRASA service relating to anything related to information pertaining Mr. Montana and a lot of the information that was required for these transactions. So effectively what happened is that he was then disciplined as well, and he was found guilty and he was dismissed. So, the struggles with the information were there because they were destroyed. And I think, having listened to Dr. Molefa's information, he expresses the same, difficulties as well and frustrations around getting information at PRASA. So we were also settled with that problem.
Well, please make available that decision relating
Chair.
to Mr. Mkholelwa
Yes.
as well.
Yes, because that disciplinary hearing was also conducted by an external party.
Yes.
So the
okay.
recordings would be there.
Yes, that's important, yeah.
Mr. Chairperson, that then is the evidence at this stage, the first stage. And as I indicated earlier today, Chairperson, the next stage we will try and wrap up all the evidence relating to PRASA, including the loose ends from here, which is why we thought it may be better to ask you if we can then adjourn today.
Yes, no, that's fine. We'll find some time in the next few months.
Yes.
To continue with the second session.
Yes.
Ms. White, do try to find information as to when that 550 million rand was paid.
I will do, Chair.
Yes. And then, of course, next time, you will still deal with the question of what, if anything, has changed.
Yes, Chair.
PRASA.
That's definitely.
Since these times.
Yes, Chair.
Yeah. Okay, thank you very much. It's been a long day.
It has.
And it's been 2 long days for you.
Yes.
We will continue on the dates that will be announced. So let's leave it at that. Then we adjourn the proceedings for the day. We adjourn. Of course, we are no longer going to sit tomorrow for the rest of the week. We were going to sit. Yeah. Okay.